Thank you so much. Honorable Chief Guest, Syed Mansoor Ali Shah, judges from the Supreme Courts and High Courts of the region, Excellencies from UN Women, European Union, esteemed judges from the District Judiciary, Pakistan, delegates and participants. We start this occasion with the recitation of Holy Quran. I would like to request Mr. Shaukat Ali, a civil judge, to please come to the stage and enlighten us with few verses from the Holy Quran. Mr. Shaukat Ali.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم هو الله الذي لا إله إلا هو عالم الغيب والشهادة هو الرحمن الرحيم هو الله الذي لا إله إلا هو الملك القدوس السلام المؤمن المهيمن العزيز الجبار المتكبر سبحان الله عما يشركون هو الله الخالق البارئ المصور له الأسماء الحسنى يسبح له ما في السماوات والأرض وهو العزيز الحكيم. He is Allah, there is no God but He, nor of the unnoticed and the noticed. He is the most gracious, the most merciful. He is Allah, there is no God but He, the sovereign, the holy, the most ideal, the guarantor of security, the watcher over all, the almighty, the compeller, the supreme. Glory be to Allah above having the partners they clarify to Him. He is Allah, the creator, the maker, the shaper. To Him belong the most beautiful titles, all that is in the heavens and on earth glorifies Him, for He is Almighty, most wise. Sadaqallahul Azim.
On behalf of Federal Judicial Academy and UN Women, it is with great pleasure and utmost honor that we welcome you all to the Regional Inclusive Justice Symposium, South Asia. This symposium stands as a beacon of collaboration and commitment towards advancing inclusive justice across our region. We will engage in insightful discussions, exchange knowledge, and explore strategies to bolster gender equality, enhance legal protections, and foster a more inclusive judicial framework. Once again, a warm welcome to each one of you. Next, I have the honor to invite Justice Syed Mansoor Ali Shah, Senior Pune Judge at Supreme Court of Pakistan, to deliver his keynote address on the topic of fostering inclusivity through structural interventions. Justice Syed Mansoor Ali Shah, Senior Pune Judge at Supreme Court of Pakistan, is a distinguished leader in judicial reform and a passionate advocate for inclusivity and human rights. With a visionary approach to transforming the judiciary, Justice Shah has pioneered numerous initiatives aimed at enhancing transparency, accountability, and efficacy within the legal system. His commitment to structural reforms has significantly improved access to justice for marginalized communities, particularly women and minorities. Known for his progressive judgments, Justice Shah has consistently emphasized the importance of a gender-sensitive legal framework that needs for institutional capacity building. His keynote address, titled Fostering Inclusivity Through Structural Interventions, will draw upon his extensive experience and offer valuable insights into creating a more inclusive judicial system through effective and sustainable reforms. We are honored to have him share his experience, his expertise, and vision with us today. Please join me in welcoming Justice Syed Mansoor Ali Shah with a round of applause. Thank you.
Thank you, Judge Shazia, for that gracious introduction. I don't know if it's really a keynote or it's just sharing my ideas today. First of all, distinguished ladies and gentlemen, Assalamu alaikum. Yesterday, I took the data of the entire country, but AJK was missed out, and so was Gilgit-Baltistan, and that's my apologies to judges from both these areas. I did not have access to data, and the Law and Justice Commission of Pakistan at that time also did not supply me with data for AJK and for Gilgit-Baltistan, so my apologies. I'm going to make sure that next time there is a session we include that data in it. So the judges from both these areas, once again my apologies for that. Yesterday, in the domain of inclusivity, we talked about representation as one key area, as an intervention. And we also talked about jurisprudence, which was very progressive, leading towards inclusive judiciary or inclusiveness, or promoting inclusiveness. Today we'll talk about a totally different thing, that's the structural interventions. And that's what I want to talk about. I think, first of all, at the very outset, let me say that it is a pretty complicated area. Do not take everything that I say to be, a truth in that sense, because we don't have a study on the subject, first of all. So my information is my experience that speaks through this session that I'm going to share some of these ideas. It also depends on some of the conversations I've had with some judges. So I don't have any solid empirical data to talk about the structural barriers being faced by the judiciary and the district judiciary in particular, and what structural interventions are required. So whatever I share with you would be some of my ideas which I've gathered through my experience earlier as a Chief Justice of the Lahore High Court, and my interest in the subject and my conversations with a couple of judges here and there. The other thing of importance is that structural interventions would obviously be, once we identify what the structural barriers are, what are the problems, structural problems faced by the district judiciary largely, and otherwise judges at the high courts and the Supreme Court, and then we can intelligently talk about what interventions are then required for that. So, to my mind, I've just identified four big areas which I think we can divide the structural barriers into, and this is not exhaustive, as I said, it's just my own understanding of the subject. Somebody who's thought about it really. Ideas, I think. Judiciary Act. So how do we constitute the district judiciary. It could be through the Civil Courts Ordinance or the Criminal Procedure Code. But what about the terms and conditions of service? There is no law as such on it. The law is the rules, which are pretty scanty as far as Punjab are concerned, and they largely rely on the civil service material or rules or notifications. So it's largely adopted from the civil service, and that's how our district judiciary is largely structured. And that's perhaps also the reason we don't call the officers or judges of our district judiciary judges, but they've been referred to as judicial officers, which personally I don't like as a term. I think they are judges, and that's internationally the term, judges for district judiciary and justices for constitutional court judges. That's how the global practice is. But somehow, because of our close nexus with the civil service laws, and we've just adopted some portions out of it, that the culture that's developed is of judicial officer, and largely reliance has been placed on whatever notifications or facilities been granted to the civil service, sort of seeps into our system also. But we've not, in these last 75 years, other than some courts, I don't know, I think Balochistan might have come up with an act also, but largely Punjab and other provinces have not come up with a judicial service act as such, which could really talk about things exhaustively and maybe meet some of the structural barriers that I'm going to talk about. So one is to let's talk about a little about the service structure itself, and whether at all that service structure, the way it is presently, is causing a barrier, and we require some interventions to deal with that. And I'll come to that. The second area is the judicial policies that will actualize that act or the service of the district judiciary. Largely, this discussion is about district judiciary, but we can certainly, take it and extend it to the High Court judges as well as the Supreme Court judges. So the judicial policies, and by that I mean policies issued by the High Court in regulating the affairs of the members of the district judiciary or judges of the district judiciary, is another thing that we need to consider, whether all those policies are gender sensitive or not. So the second area is the judicial policies, and who makes these policies and all that, and I'll talk about that in a minute. The third is the actual hardcore brick and mortar infrastructure barriers, the working environment, and we touched upon that yesterday in the shape of toilets and all that, but there's more to it, and we'll talk about the working environment and how does a woman judge feel in her environment as a judge in the district judiciary or even at the Supreme Court or at the High Court, and that I'll come to. That I think is another barrier. Then there's another barrier for which I still don't have any information or expertise to talk about, but it's certainly a barrier, and that's how does the legal education, the legal profession dealing with women, and whether at all it is inclusive, whether at all it is gender sensitive, and whether at all it is promoting women into and propelling them to come into the judiciary later on. How does the law firms work? How do the law schools work? This needs to be seen, and whether at all they're conducive, and are they really preparing young women to come into the profession. When I say profession, I mean the judicial service. And lastly, I would think there are serious cultural and social barriers also, which stand in the way of women to come into the judicial service. Now, once again, I'm no expert. I'm not a sociologist. I have no expertise, neither do I have any study to understand what are those patriarchal interventions or problems or barriers which are causing this. I hear that a lot of people think that if a woman is gone or their daughter is becoming a lawyer, it's a bit rebellious on her part to become a lawyer, and if she fights for her rights and all that, that makes people uncomfortable. So in a patriarchal society, anything can happen. I can't really put my finger on it, but this is I get a sense that culturally and socially there are issues which are also impediments in the way of women to come into the legal profession, leading into the judicial profession. So I look at it, I start off with the first one, but I look at the whole issue with a constitutional lens, because that helps me cut through this. So I start off, it was referred to yesterday also, Article 25(3) to start off with, because the Constitution allows us to discriminate in favor of women or take that affirmative action. So the main plank of most of the policies and the law that one wants to structure later on would be, because the Constitution allows us to go ahead and prefer women over men. And that is very important. That's a constitutional support that you get. And read with the principle of policy, which is Article 34, which says that steps shall be taken to ensure full participation of women in all affairs of national life. That the word full participation is there, and when you read it with Article 25, which I'll repeat for people who might not recall, is that all citizens are equal before law and are entitled to equal protection of law, but nothing in this article prevents the state from making any special provision for the protection of women. So we can go the extra mile for women, and we may, to ensure that there's full participation. Yesterday, we discovered that 16% of our women are in the judiciary. And we also discovered that the demographics of this country is that 50% of, almost 50% of the population of this country are women. So we saw there's a gap. Why isn't that demography reflected in our judiciary? Why do we are stuck on 16%? Why can't we move it up to, ideally, 50%? So that's the objective of the entire symposium, as I see it, that how do we move up that 16% to 50%, and what is standing in the way? I mean, what are we supposed to be doing, or what are we not doing that we should be doing, that we move 16 to 50? And then we talked about representation, we talked about other things. But in that context, in that very context of moving that percentage from 16 to 50, we talk about structural interventions, and I've highlighted some of these areas. So with these two provisions of Article 25(3) and 34, I would sort of also refer to Article 14, which is right to dignity, which I think is a very strong fundamental right, and then right to liberty and life, that's Article 9. So this basket of constitutional rights need to be behind us to look at the policy and the legal profession, the legal area that we need to talk about, the Act and the law, the Service Act itself. So coming to the first one, legal barrier, that's the legal framework, then the construct of the judicial service. So first of all, as I said, there is no judicial service.
Hello.
These years we never came up with this.
Hello.
So what would be the fundamental areas that one would like to consider when you sit down and come up with the Judicial Service Act? So first thing to my mind would be to concentrate on the appointment process. There has to be a full-fledged chapter on appointments in that law that we hopefully would make one day. So when we talk about that, what kind of appointments? And there I would say that we need to consider gender quotas. That's to my mind very important. I think that draws its strength from Article 25(3) itself. This is irrespective of the fact that yes, on a general seat a woman can certainly apply, but in addition to that, this is not belittling in any manner the women applicants who apply for this position. In addition to that general seat, there has to be that extra mile that Article 25(3) says. If you really want to push up the number from 16 to 50, there has to be some gender quota. And I just discovered this morning that we follow in the district judiciary the notifications of the government in our appointments in the year 2010 that I discovered in Punjab. There was a 15% quota that we followed for women at that time, and then I don't have much research on the subject whether it all was followed later on or not, but there has been some sort of notification followed earlier by the High Court in Punjab in appointing some of the district judiciary members, and that was 15%. So I'm saying other than the general seats, there has to be the general quota looked at, and that's something I'm leaving all these thoughts for all of you to consider and percolate, and also for the panel that comes up to consider whether at all this is right or not. I mean, this is not a final word, but I'm just saying these are some of the ideas. Secondly, it could either be gender quotas or the women applicants could be considered first. And if they do not make it, then we move on to men, because we're giving preference to women. So this could be another option provided in the law, that if the applicant should apply, this law would stand as long as Article 25.3 stands, because 25.3 is allowing you to do this. So there could be that you give preference to women applicants first, and if they do not meet the criteria, then you move down to men and consider them. The recruitment committee, however, must have women. This is very important, and because it is to consider women, as there will be applicants who are women, so the recruitment committee has to have women, and ideally if such a law promotion that is merit-based, and there is a very intelligent criteria developed, and we give merit the due credit and take people up the ladder so that they're not stuck, because everybody has to go up the ladder first. But people who are clapping must remember that there will be a merit-based system. So we'll see. And while doing that, we could also then go the extra mile, because you didn't hear this one. You go the extra mile and give preference in that promotion to women again, because of 25.3 again. So that, now I hear the other class. So that could also be, and I'm just thinking, that could be an idea. So, as you see, I just read this quote of Melinda Gates, and I thought it was very interesting. I want to share that. A woman with a voice is, by definition, a strong woman. So I'm saying the minute you get more women into the system, the voice is going to become louder, and I think they'll take care of their matters themselves. Then comes the other issue, which is very critical. It has happened now, it's now a political issue to my mind, is the lateral entry of additional session judges, for additional session judges from the lawyers category. Now, to my mind, if you look at the system, the blockade is because of this also. People are not moving up the ladder from normal civil judges onto additional session judges because there are 40% are coming in from this lateral entry of lawyers. So there could be a situation where there is a lawyer who has about 10, that the law requires them to have 10 years experience. So there could be a situation that there is a lawyer who's entering the system as an additional sessions judge with an experience of 10 years, is trumping the possibility of promotion of a person who probably has more judicial service, and that's a problem. That's not very fair as I see it, because you might have a civil judge who has 15 years of experience, of his earlier judicial experience, and you put it together as 15 years or 20 years, and here you have a person who's 10 years and comes and becomes senior, blocks this path also. So that needs to be reconsideration. I don't know if we can do it because the bar is now deeply invested in it, and it becomes a political issue, but we can consider it, whether or not we can stop it for a while and give preference to our judges, or maybe we can come up with a policy that judges who have more judicial experience need to be preferred first, and when we come to those judges who have less than 10 years judicial experience, we open the gate for lateral entry. Maybe these are some of the thoughts. And also when we talk about the lateral entry, we could also then talk about giving preference to women here also. With the subject of the formula that I talked about, we can talk about women coming into lateral entry as a preference, because that preference system needs to be built in on the basis of Article 25. Just a thought, I don't know, one needs to think deeply about these issues later also. Then I think the Act would also talk about, we need to open this track going up to sessions judge, and that is creating a lot of frustration. And that could also be that we could have district judge looking at criminal division, we could have a district judge looking at civil division, we could have a district judge perhaps looking at family division, and you have three session judges in a district that opens up the room for people going up. Having said that, I mean, we could have a similar model of a chief district judge in a district, and he would be the senior most judge at the administration part. But I see no reason why we cannot have more than three or four district judges in a district. So that would also open up that. And when you open up this, then number of things happen. And as I said earlier, I qualified. When you open up this track, we are opening up along with this track preference cards also, women going up also. So women are actually going a bit faster than men if we put the policy in place. Once you open the track, the women are the most advantageous of this new open track. So that will make a difference. We're just finding ways on how to get women into the system, which is also helping men also clear the system a little. So then the next thought that sort of crosses my mind, I was in New York and I was attending, and some of my colleagues were there in New York with me. We were attending the World Jurist Association function. And the president of the World Jurist Association asked me, do you judges have associations? And I said, I haven't heard of that. And he said, why not? I mean, we have about, I don't know, number of countries here who are being represented. They all have associations. Why don't you have associations? And I said, well, I don't know, something that I need to think about. So I was just thinking, why doesn't district judiciary have an association? Why can't judges of the district judiciary have association? I think it's a very democratic principle, is it not? It's very democratic to have your voice heard through an association. And then within the district judiciary, you could have a women judges association, which would then talk about these issues that we're trying to talk about and fight for. Then they will fight for it themselves. So I think empowering women would not be just, give them a toilet here, which is certainly we will, but the issue is to give them, a sustainable system where they could then take care of matters themselves. For example, if we were to have this association of women within the association of judges, I think there'll be a very strong voice. They'll fight for it. I think harassment issues or transfer issues, a number of other issues could be talked about. As a Chief Justice, I felt that I wanted to talk to the district judiciary and I didn't know how to talk to the district judiciary. Who do I talk to? The registrar? Okay. Or the MIT who's always against the district judiciary somehow. So who do I talk to? And I tell you, this is a very odd thing that I've realized. MIT is out of you guys, and when a minute he becomes MIT, he says all these guys are bad. And I don't know why this happens. This is very odd, but anyway, we changed the term MIT also, which is also borrowed from the civil service. We turned it into a Directorate of District Judiciary in Punjab. I don't know what's the position in other districts, so other provinces. So association is another thought that we can think about. And that association, to my mind, takes up on its own momentum, would solve a lot of problems that we have and we're facing right now. So why can't we have this association? And tomorrow, Chief Justice of our province wants the issues that the association goes to the Chief Justice, says, these are the problems, sir. We're facing these problems. Nobody can communicate with the Chief Justice right now what the issues are. The Chief Justice will talk to some of the session judges perhaps, and who are close to him, or who he feels are credible names. But is that the way it should be done? So we at the High Court created not an association but a committee of various judges from various tiers, and we thought that was a corpus, that was a sample of representing the district judiciary, so I could hear what a civil judge has to say, what a judicial session judge has to say, what a female civil judge has to say. How do these voices get to the policy makers? I don't understand. I seriously don't understand that. How do your voices get there? By training, you're very quiet and decent and you don't really say anything, because that's how the training is. And so I think association could give you that voice, and I think that needs to be considered. Whether at all, how do we do that, that's another issue. So as I said, there could be an association, but short of an association, there has to be some sort of a board or some sort of a body of the district judiciary. Suppose if you don't go the association route, there has to be some board of the district judiciary that I or anybody wants to talk to. Suppose I want to talk to the district judiciary in Balochistan. Who do I call? Is there a number? Who do I call? And is there a board and board of directors or board of whatever, members and something like this, who would tell me what are the issues of district judiciary in Balochistan or other provinces? So that model needs to be considered. Why am I saying this is just to empowering all the judges, but in particular, women gets empowered through a systemic change rather than just one-off interventions here and there. So I think it's a more sustainable kind of system. That's one. So we need to come up with a Judicial Service Act that may talk about all these various factors, give you a robust terms and conditions, and give you a system where there could be more voice that comes out and they can sort of attend to their issues. The second issue was the judicial policies. Now, I think largely district judiciary is run through these notifications and policies right now, because there is no act for that matter. So the Chief Justice were to decide that finish 100 cases, please work hard, do these things, that kind of policies keep coming. They say, please decide all these cases and all that. But we have to see first and foremost whether all these policies are made, where are they made? Now these policies are made, as I see it, by the Chief Justice alone at the High Court level. So the first structural change I would suggest would be that the policies ought to be made where women are sitting with the policy makers. So this body which is making this policy must have some women. I mean, how would the Chief Justice know what policy to make alone if he's not a woman? So to start with, if you're making a policy at the Supreme Court, at the High Court, at the District Court, the policy body that's making the policy must have women. That's one very important factor. I'm sorry, I'm told there is a time limitation, but I need to say a few things. Don't mind my just exceeding a little time. Can I speak a little more? So now, will of the people have spoken. Okay. So having said that, because that's very important, that the locale where the policy is being made, you need to have a woman sitting there. And it would be very unjust and very unfair that a man were to make a policy for large number of women in the system. That's slightly counterintuitive. Then we move on, that the policies should largely be to support work-life balance, flexible working hours, parental leave or leave issues, child care facilities, or so crucial for supporting women judges and staff. I haven't yet seen many such policies. I think the leave rules are the leave rules of the government. There is no proactive policy that goes ahead and provides a work-life or recreational facilities or working hours, or as if we've sat and thought about our judges and we say, okay, let's see how should they be working actually. I don't think that's happening. And we think, and I think we should do that, and we need to deliberate more on how to come up with these policies. We need to come up with a policy regarding anti-harassment, but let me also talk about this harassment issue. Current system, nobody's going to really, to my mind, talk about harassment because that's just getting you nowhere. A woman, suppose, God forbid, she's being harassed. If she raises that question, she becomes visible. She doesn't know where to take this matter. Maybe nothing happens, and she just, takes an issue and can't really take it to a closure. So once we have more women coming into the system, once we have that association going, or once we have a body, I'm quite sure that these issues will be handled very well, because that voice will be stronger than the voice of this individual woman who's trying to raise this question about harassment. So once again, that side note that I put on the table, that we must try to get them in irrespective, and then talk about a number of other niceties that we're talking about. Policies that ensure women taking on a leadership position. We need to have policy which by design provides that women end up taking leadership positions. We don't have such a policy where we make sure that they become session judges, they take up positions at the Federal Judicial Academy or at the District Directorate of District Judiciary or others. And also, which is not the subject today, is the training part, which must provide. There are leadership training programs at the Federal Judicial Academy. Are we really also, and I think they are doing something on this, where we're preparing female judges for leadership positions. A dedicated course where we can, so that we tell them that yes, you could be leading the district, you could be heading the academy, you could be doing a number of things. So that kind of a thing needs to be done. We need to also consider whether at all there could be a more gender-sensitive transfer policy. Now that carries a lot in it, and we talked about it when we were at the High Court, that children are studying, there could be a maternity issue, there could be a number of things, and off you go due to political reasons. The Chief Justice decided to transfer you. That should not happen. The transfer has to be purely through a rule-based system. It cannot be on the will, just because we just shift somebody. Number of cases this has happened, that you shift a person, the kids are being schooled somewhere, they can't be moved, the woman moves on one side, the husband is on the other side, and it totally disrupts the system. And I would imagine if I'm transferred in that fashion, I tell you, I can't do any judicial work properly. But anyway, everybody goes ahead and does it, they can't raise their voice, but I think that's very disturbing. And also, on the policy issue, lastly, this has to be an organic document, has to keep growing, has to be developing as we go on. We keep on making adjustments. It can't be made a policy and then we sleep over it. No, there has to be, and I propose, and I think this is an idea that I picked up from LUMS, but I think we need to have a diversity and inclusion department within the judiciary. And I think that's very important. And this diversity inclusion department will constantly be looking at our policies, constantly advising us what's going on, and that organic policy system making keeps on changing, addressing the current issues as they arise. So I think this diversity inclusion department should, as a policy, be made in all sorts of courts. Then coming to the other fundamental issue, and I'm exceeding time, and I think the organizers are getting upset, but I think I can get away with it. So the third thing is the infrastructural issue, the actual brick and mortar problem, and this has to be more conducive to women. I have seen that in Punjab, and I referred to it yesterday. The courtrooms, to start with, are pathetic. I mean, I have seen courtrooms which is as small as a toilet, where a judge is sitting, and the only wall between her and her reader or the almad is the shelf itself, the almari, which is the wall. And that is where she is, and she's practically sitting on the road, and people outside standing on the road can see her dispense justice. And that's not right. That's just not right. I, as a judge, could not possibly operate there, and I don't know how women and young women sitting in far-flung districts in such an environment are operating and dispensing justice. My salute to you for that. My salute to you. So this design, and then we can go on endlessly on the design issue. We can talk about toilets, we can talk about prayer rooms, we can talk about common rooms, number of things. I mean, attached toilets, all sorts of facilities, and that's important, and that's something we can't just lightly take, because the needs are different for women and the needs of men are different, and we need to understand that. I mean, there are issues which women need to address, and that we need to provide that privacy and space for women in the system. That applies to Supreme Court, that applies to High Court too. But we must signal a commitment to gender equality and inclusivity in that sense, and we're not doing that. So proper courtrooms, as I said, and I'll just rush through this, I think we haven't yet come up with any recreational facility for judges. All we hear is, please finish 100 cases. That's all I hear. And I haven't heard, okay, what do you do in your free time? Where do you go? How do you chill? How do you relax? What do you do? But how do you unwind? Nobody is interested. Just finish those cases, please. And those cases will never finish, and I tell you that. They'll never finish. We will finish, the cases will never finish. This is a myth to say that the pendency is going to finish. It cannot. Then we must come to terms with that. So what about a gym? What about a child play area? What about a prayer room? Is there a policy? Any high court has a policy which says, women, this is your prayer room during the day. Where is it? So they'll have to go find a place somewhere themselves. I mean, what kind of a policy is that be? So are we holistically looking at our district judiciary? Are we really understanding their needs? I'm talking about the policy makers, that's us. And are we sitting sometimes and talking about it? I don't know. I mean, I haven't spent any time where my judges and I sat down and we said, okay, what policy should we make for our district judiciary which would make them very comfortable? I don't remember a day when we had a meeting to this effect. And I'm talking about my tenure as a Chief Justice of Punjab, never. So then I would assume that maybe no other high courts haven't done either, but if some have done, credits to them. The other idea could be on the infrastructural idea would be that if we go around and have one judicial complex in every district. We have a judicial complex, but you have ex-cadre courts scattered all over in various plazas and all that. One big judicial complex with housing, with courts. And that is it. Instead of having all these, plazas and courtrooms, this is not difficult. This is not difficult. It caters to security, it caters to your housing, you can have your own playgrounds inside, that's your little estate. You go, you work in the morning, you have your housing there, you have your families there, you stay together, you work together, you bond together. I think that's one idea that one could float, that one single judicial complex per district. So that sort of security. The other issue, which is slightly more complicated, is the security issue. So if I were a woman and I've just graduated from a law school and I'm working at a law firm, and I say, well, if I become a civil judge in Punjab and I'm thrown at some of the districts, the lawyers insult me. They are very rude to me. And I don't know if I can handle those. And that will be my question to myself and to my family, that they insult you, they swear at you. Have you seen the things in Punjab, how the bar attends to a woman? That is not on. So that has to be done, and I don't know where bar members are. We need to talk about these things openly. We need to sit down and have a heart-to-heart on this. How will this work? How can you go ahead and insult judges? I mean, we need to really sit down and talk about it. In Lahore, in Punjab, we shut down districts where they insulted a woman, and then it remained shut for a while and we opened it later on. So that's not on. Then also the behavior of their peers. I mean, this is also a problem, that a woman who's working, she's getting all this flack from the lawyers. All right. Then she's also getting a lot of flack because the peers are not getting her. They're not understanding her. And I blame them for that. They're not sensitized enough to deal with this issue, and that sort of takes us to training and all the other issues. But this is also an issue that I would think, if I am a woman and I have just graduated and I want to apply for a civil service job, I say, well, the judges don't understand. What if I'm in a far-flung district? My peers will have no understanding. What do? I'd rather not do law. Let me go join some other department. Because today, and yesterday and today, we're thinking about how to woo women into judiciary. So we need to provide a conducive environment for that purpose. So we need to think of all those things that worry us, you disturb us. We need to take those disturbances out, clear the air, so that we can get women into our system. And as I said yesterday, there has been a huge decline of lawyers, female lawyers applying for the post of civil judges. And that's very depressing, by the way. And then, of course, infrastructurally, should the judge, a female judge, have a female staff? Or do you want a man coming into her office all the time, even to attend to some of her very personal things? Should we not have a female staff? And yesterday I told you there are about 2% or 4% female staff out of 48,000 staff that we have in the country. So that needs to be considered. And then, of course, we need to also empower them. We try to do that in Punjab, but I'm sure the other provinces have done that also. Give them cars. Women must have cars. They must have, feel empowered to come to work, and a number of other things, and that list goes on. Then moving on to two other things, and I'll be gone soon. ये छोटी सी दो बातें और थी. Legal education and legal profession. We need to, and I don't have a study on it, and I think I would request somebody to do a study on it to understand, is the legal education tuned towards preparing young lawyers and giving them a vision that you could go join the judiciary also. I don't know if that conversation takes place at the law schools. Should we be reaching out to the law schools and telling them that here we are, we've come out to roadshow and tell you that, listen, we have a thing called judiciary, and why don't you sort of join this, and why can't we talk about to your students about it? So something like that, I don't know, but that has to be done. I don't know law schools really talk about that. I also feel that the legal profession, the law firms are not really geared towards that either. And I don't know how comfortable it is for women to work in law firms. I've been hearing things since yesterday that all sorts of things, the things are not very comfortable at law firms, and things are not too comfortable, around and going out to court. There is hardly any trust or confidence. They don't repose trust that you go ahead and go litigate this matter. So that's something beyond my domain and jurisdiction, but a study should look into that. What's happening? Why I don't see women in the court? Why don't I see them in the Supreme Court? I see very few of them. Where are they? Where are the women was the question yesterday. So that's the law schools part. And lastly, once again, which if I'm not an expert, is the cultural and the social barriers, which is the mindset of the society. Now that I can't, of course, as a judge and as a part of the judiciary change. We can change that through our jurisprudence, of course, but not otherwise. And that's another issue that we need to all think about. Do we send our daughters out to study law? Do we have a problem in our daughter becoming a judge, a civil judge for that matter, or applying for that? And if there are problems, that's a barrier for her. And that is something that, a societal issue, but it is certainly an impediment that I wanted to put on the table. And these things will have to go, will take time, but will go. But awareness, programs like this would be something that would help in that direction. So these are some of my thoughts on how structural interventions could take place. It's a big basket, a number of things, but I think if we start working on it, start thinking about it, and I urge the panelists that are coming up to please think about this more deeply and see if we can find solutions. But the ultimate aim is how to bring more women into the system, and that is the judiciary. And these were some of my ideas, but looking forward to your ideas also. Thank you so much, and sorry organizers for delaying this.
We deeply appreciate the enlightening address. Justice Shah continually serves as an inspiration and a beacon of guidance. And Justice Shah, we can hear you the whole day long and we won't get tired, but we had some time restrictions. We are sorry for that. Now we have another panel to continue this discussion. Promising practices for meaningful inclusivity, the structural interventions. The panel will provide a comprehensive overview of successful strategies, identify areas for improvements, and proper actionable recommendations to enhance inclusivity through structural interventions. The discussion will cover the effectiveness of legal framework, enhancement of institutional capacities, and the importance of changing mindset. It will focus reforms in the Maldives judiciary, the current reforms and challenges in Pakistan, insights on India's legal framework and institutional capacities, inclusivity efforts and challenges in Bangladesh, and how mindset changes within judiciary and institutional frameworks can foster inclusivity in Pakistan. The discussion will cover legal frameworks, institutional capacities, and changing the mindset. I will request the panelists, and I will be calling them, inviting them one by one. Justice Aisha Shajoon Muhammad. Justice Aisha Shajoon Muhammad, a prominent legal professional from Maldives, was appointed to the Supreme Court of Maldives in 2019. Before her appointment to the Supreme Court, she served as a judge of the civil courts in 2007. Justice Shajoon has significantly contributed to the legal sector in Maldives, serving as executive as well as judicial positions, on judicial positions. She also served as the Judicial Academy of Maldives and the Faculty of Sharia and Law at the Maldives National University. Internationally, Justice Shajoon Muhammad has been a key figure in the United Nations Subcommittee on the Prevention of Torture. Additionally, she is a member of the advisory group of the Judicial Integrity Network. We are honored to have her here. I would request Justice Aisha, another Justice Aisha, an inspiring figure, to the stage. Justice Alia Neelam. Justice Alia Neelam, a respected judge at the Lahore High Court, is dedicated to enhancing institutional capacities to support gender justice. Her work has focused on developing legal frameworks and judicial practices that promote inclusivity and address gender disparities. Justice Neelam's commitment to judicial reform and her insights into the challenges and successes within the Pakistan judiciary will be invaluable to our discussion. She has been heading the GBV courts of Punjab as well. We are honored to have her here on the stage, Justice Alia Neelam. Ms. Madhu Mehra, she will be joining us through Zoom. Has she joined us? Ms. Madhu Mehra is a feminist lawyer, founder and former director of Partners for Law in the Development, a women's rights organization where currently heads researches and training initiatives. She is also currently heading research trainings initiative. Her work on child, early marriage, sexual and gender-based violence, targeting of women as witches among others critique the prominent reliance on criminalization at the cost of transformatory victim-centric approach. Her work on CEDAW nationally and regionally in Asia as a trainer, researcher, writer, and in civil society possesses assisting the country reviews undertaken by CEDAW spans nearly 30 years. Her contribution to gender policy in relation to SGBV was recognized in a political 100 most influential in 2021. Ms. Madhu Mehra will join us online. Ms. Kamroon Nahar. Kamroon Nahar is a dedicated human rights lawyer with 27 years of experience, specializing in legal aid, violence against women and children, the policy and policy advocacy. She has worked extensively with Nari Puko and Rangpur, Dinajpur rural services, focusing on capacity building for judges, police, doctors, and officials. She is also a technical committee member of the Rape Law Reforms coalition in Bangladesh. She will also be joining us through Zoom. Ms. Fawzia Waqar. Ms. Fawzia Waqar is an expert on women's rights and empowerment recognized widely in Pakistan and globally. She serves as the Federal Ombudsperson against harassment in Pakistan, as the founding chairperson of the Punjab Commission on the Status of Women. She led policy and legislative reforms to eliminate discrimination, violence against women. She has advised large governance programs across Pakistan to support government and international organizations, including UN agencies. Ms. Waqar has also worked abroad to eliminate racism and gender discrimination as an advisor to the Government of Ontario. We welcome you, Ms. Ms. Wadia Mushtaq Malik, with a Bachelor's of Law and Arts, joined the judiciary in 2004 as an additional district and sessions judge and reformer, director instructions at Khyber Pakhtunkhwa Judicial Academy. She has championed gender justice, child protection, and human rights, notably establishing first child protection court in Khyber Pakhtunkhwa. We welcome you, Ms. Wadia Mushtaq Malik, on the stage. I am moderator for the session. Thank you. Can you please give us the view of the online panelists? And I think we should have the lights on because there is too much darkness over here. So, starting with the discussion, my first question is to Ms. Aisha Shajoon Muhammad, Justice Aisha Shajoon Muhammad. Like I am questioning you about how the cultural and current legal framework in your country, Maldives, impacted inclusivity within the judiciary, and what specific reforms do you believe are necessary to enhance these frameworks? But I would also like to give your input. What should we do to attract women toward judiciary, and how we make system more inclusive? Over to you.
Thank you very much, and thank you for having me. Assalamu alaikum, everyone. First of all, I think I will touch on something that is very dear to me, something we have talked about yesterday as well, and something Justice Aisha, Justice Sapna, and other justices from the region have worked on. That's the Bangkok General Guidance. It's a document we had, although it was initially adopted to the Southeast Asian region, originally in 2016, we had tweaked it to be applicable to the South Asian region as well, and the document has been there since 2022. I would like to highlight for your reference, and I would urge you to look at it, that it contains guidance on application of gender perspective on judicial decision making. It talks about concepts, and it has also recommendations for institutional policy. So a lot of things we have been talking about yesterday, and I would assume for the rest of the day today, it has been somewhat worked on, and I have been working on gender issues for decades, all my adult life actually. So it's an issue very dear to me, and I would urge you to look at it. And it was a document that we had met on, discussed on, and all these things. So I would urge you to look at it. Going straight to the question, I will talk about, strategies to encourage more women into the judiciary, and strategies to foster meaningful inclusivity for women already in the judiciary, as Justice Shah also alluded to. But by way of background, because the Maldivian system is slightly different to yours, we have had, historically we know we have had some sort of judicial function for over 800 years, but the more modern structured judiciary came into being in 1909 when an office called the Mahkamat al-Sharia was established. But it wasn't until the enactment of the current constitution in 2008 that the judiciary became independent. I say this because prior to 2008, the trial courts were more or less under the Ministry of Justice. The High Court was under the President's office, and the highest appeal was to the President himself. So in 2008, what happened was we adopted a new, very robust constitution with separation of powers, clearly saying that each arm is separate from the other. For the first time, we had a Supreme Court as well. So that's by way of background. Until 2010, and then going back, we didn't have a woman in the judiciary until 2007. So the first time a woman sat on the bench in the Maldives was in 2007. I had the honor to be one of the two women, along with now Justice Josefa, who's currently in the High Court. But until 2018, the numbers didn't, it fluctuated, sometimes lower, sometimes higher, but never above 10 until 2018. But by the end of 2023, the total number stood at 30, which was a 200% increase, but that's 30 out of 150 altogether, because we have altogether 150 judges. We are a population of 500,000, so the numbers are not as massive as yours. But what led to that massive increase or rapid increase, I would like to share. So what happened in 2019 was our Judicial Services Commission, which is a constitutional body which is independent to the judiciary itself, and it's based, it's developed similar to the South African Judicial Services Commission. There are criticisms against it, but it is what it is as currently. But in 2019, for the first time, a woman headed the Judicial Services Commission. And then consecutively, what happened was in 2019, when Supreme Court, 2 judges, including myself, were appointed to the Supreme Court, I went into the Judicial Services Commission as a representative of the Supreme Court. And what we did there was we made conscious effort to have more inclusive recruitment policies. So we encouraged women to apply, and also we gave them priority where women showed the same merit as male applicants. What had also happened was in 2019, when we were appointed to the Supreme Court, the number of female applicants increased. This, I suppose, as a background, I should also say, I'm surely going to run out of time. We have a large number of lawyers in the prosecution and in the Attorney General's office. About 80% of the lawyers in each institution are women. So it's not for the lack of women lawyers that this had happened, it was a lack of will, I suppose. But in 2019, when we were appointed to the Supreme Court, the applications increased. We started with a policy of recruitment where women were given preference, of course, based on merit, though, and taking into consideration where women had to go and reside in islands, whether they would be able to move with their families, and all these things. Of course, there are gaps, but then we tried to, as much as possible, to accommodate and women, so that, and where we could not in one tranche of applications, we would still get in touch with them for the second tranche. The other thing we also did, so one of the takeaways is that women in decision-making matters, and between 2019 and 2023, the policies developed were very, very conducive to that. And in terms of attracting women into the judiciary, we knew, and a lot of others knew, that there were several issues faced. We ourselves had the toilet issue in 27. I can remember when I was initially appointed to the civil court, which is a specialized court. Because there were no female judges, there were no female toilets. And I will not relate the story here, but then I had to actually embarrass my male colleagues to get a toilet myself. Anyway, and also currently what happens is whenever a new building is erected, we make sure there are toilets for both as well. I suppose we can talk about toilets all day. I can remember when we had a conference in Maldives, it was, we had toilet stories for about half a day. And this was from across the region. So while it may be funny for some, for us, not really. Other things we knew and our issues are that men, even counterparts, often insult us. And not always, but most of the time they mask it as a joke. And shall I continue? Okay. And if they see, and if we retaliate, they will stop. And one of the things we have started to do is to tell the women during induction, so this is what's going to happen to you. So you'll be alert. If you're having problems, call me. I'm going to help you out. So we do a lot of mentoring as well. We are also viewed as kind of secretaries, although we are their equals, because every time we would have a committee or something, the men would want to do all the talking, and us, they would want us to take notes. I'm like, excuse me, that's not going to happen. So things like that. And day before yesterday, when we visited the exhibition, I also noticed that this was an issue here that we are addressed in a derogatory manner. Now I am at the Supreme Court, so you will refer to me as justice. You will not refer to me as anything else. So that is, yeah. So while I might sound rude asserting that, I don't think any of my male counterparts need to say that, so why should I? So I will assert that. Harassment, improper conduct are issues. There are fears that if women are brought into the judiciary that they will get married. Hello, men get married too. That women will get pregnant. Women get pregnant with men, and therefore, just because our physiology, we shouldn't be at a disadvantage. But all these things are now inserted into the induction program, where we also talk about these issues with both male and female judges who come into the system. We did also a study on sexual harassment in the workplace, and we seriously consider issues of harassment in improper conduct. One of the key things we also do is mentor women judges by women judges, and that makes sure that women judges have access to senior women judges. And in terms of training, women judges are given slots for training and exposure purposes in country and overseas, because otherwise we would have a rotation system and they would never get into the loop. We also started hosting a women judges conference. This was the second year we have it, and that has gone a long way. And while we had hoped after the first conference that more things will materialize, it did not. So this year, when we had the Women Judges Conference, we kind of thought, okay, we're going to take this into our own hands, and we have developed our own action plan, which the judicial administration will help us implement. And we also adopted a resolution to say we are going to have a Women Judges Wing within the Judges Association, and we are at the cusp of getting that done. Public mindset, yes, is an issue, and I can remember when I was initially being inducted into the judiciary and subsequently into the Supreme Court, there was massive media campaigns. Oh, is she good enough? Does she have enough experience? Does she have the necessary educational qualifications? My family was brought up all these things. But these are never asked of the men. Why the double standard? Just because I'm a woman. But then we've also subsequently found out with the judgments and everything, which at the Supreme Court level and the High Court, it's publicly live cast except in-camera hearings. And people have started to, despite their dislike for women, I think people have started to respect that women stand their ground. So those mindsets slowly change. I'm not saying everybody's is. But I think at the end of the day, we have to make a concerted effort to know what we're doing. We've been talking the talk for I don't know how many years. Now we need to start walking the walk. And it shouldn't be that it shouldn't be about concern about power or letting go or anything like that, but then a genuine desire to actually address the issues for meaningful participation. I hope I've been helpful and that it's been somewhat giving you ideas.
Thank you so much, Mrs. Aisha Shadun Muhammad. With the permission of my co-panelists who are still sitting here, I would like to take my next question to Madhu Mehra from India. So ma'am, how have the current legal frameworks in India impacted inclusivity within the judiciary, and what specific reforms do you believe are necessary to enhance these frameworks further? My next question would be, can you share examples of successful structural interventions in your country and its judiciary and in or institutional capacities that have significantly improved inclusivity? And additionally, what challenges have you faced in implementing these interventions, and how have you addressed the need for mindset changes within the frameworks? Over to Ms. Madhu Mehra.
Thank you. I'm very honored to be part of this symposium. Thank you for having me here. And good day to all the organizers and the fellow panelists. Let me just, given the time constraint, focus on precisely some issues that I have been directly involved with. Yes, I understand inclusivity as being very broad and as being a constantly work in progress. It's a never accomplished, it's never finished, because our laws were designed for what is a reasonable man, a male standard, and the male standard too did not sort of think about men from marginalized populations. So the struggle to make the justice system inclusive, including the judiciary, is a long one. And yes, representation is one pillar of that, or one piece of that. But there are other pieces as well, such as making laws that are enabling legal redress for groups that are otherwise not, were not seen as visible. We've had, of course, a history of law reforms for women in India, but it was much later that we considered disability, and we have recognition for LGBTI, but still sort of not a proper, robust legal framework, I would say. Children were recognized much later in the day, and so it is really a work in progress. I think architectural changes have been elaborated by the panelists, and it's been they're so significant for women. Women who are working as judges, but also women as lawyers. In my brief stint in litigation, that was something that was, clearly an issue. But besides that, I think in terms of architectural change, one reform in India, though it's not universal, it has sort of certainly is available in Delhi, is the vulnerable witness protection system, which allows children and women who are considered vulnerable witnesses to give their deposition in a safe space, and they're not directly in the courtroom, right in front of the other parties, most significantly the sort of accused. So that is definitely a big step forward, but to make such architectural arrangements, it takes a long time. Disability access is still something that is, not available fully. But I think that again is a very important part. But ideological change is where we really, no matter how much we change otherwise, we might populate judiciary with women, but to bring about real ideological change, because the judiciary as a whole needs to engage with the cross-sectoral issues. They can't just be women judges looking at women's issues, or looking at disability issues, or looking at children's issues. So I think that's a big stumbling block, and to remember that just because women are appointed, they're not ideologically sensitive. That's an effort that has to be undertaken. And it's again something that has to be seen as a continuing process, not one time or annual kind of event. I think that's where we stumble most. And I would say one of the tools we have used as Partners for Law in Development, my organization, has been undertaking socio-legal research to see really where the gaps are in inclusivity. And I would say that, research gives us such rich data, such deep and layered data to understand where the gaps are, and we really need to invest in that, because as the judiciary, we are actually, with all the cases that are before us, we are a repository of so much information. One part of which can be, of course, justice delivery, but the other part is to understand really what is the texture of justice that is being delivered through the judiciary. And let me give you 3 brief examples, so I'm within time. Our work on, in 2013, we had rape law reforms, which were quite fundamental in our country and incorporated many advancements that we had been advocating for. And one aspect of that was victim-friendly procedures and responses. And soon after 2013, our organization undertook a study with the support, of course, of the Department of Justice, where we looked at the cases under the new special courts. And one aspect of research is socio-legal research, which requires us to not just look at what the legal documents are, but also get access to victims to speak to them. Because legal documents often give us a picture that we can't corroborate with any other source. And I think that was very revealing, that although the process appears to be on time and moving forward, but what the victims share is the difficulties right from the start, from registering a first information report, which is often extremely tedious, and they are discouraged repeatedly. So, and of course, then the medico-forensic examinations, where although 2-finger test has now been sort of struck down, but still continues in practice. Medical aid, which is definitely part of that, is often not seen as necessary, because a medical examination is seen as only a lending itself to forensic purposes. So I think those were some of the issues that we discovered, which really become barriers for women to access the system. Another thing that we realized is that although justice is concerned only with, with the accused, most of the women had to relocate. Most of the accused could not be found in their addresses. So if there is a social dimension of sexual violence, then that remains a gap in all our justice systems, that we don't address the social consequences of sexual violence. We are concerned only with convicting the accused, and very often the evidence is not beyond reasonable doubt. The second body of research we undertook on targeting of women as witches And we looked at from the police thana in the village level to the appeal court level. And what we discovered was very interesting. And again, that depends on the tools you use for research, and research methodologies can be either very static or quite dynamic. What we found is stories that women tell of being targeted, abused in an everyday form, which don't allow them social interaction, which sort of excludes and ostracize. There is no redress available for that. At the police thana level, what we found is unless there is mob violence, a case will not be registered. So the everyday routine humiliation, exclusion, social and economic boycott is not redressable, although the laws do provide for redress. So I think that's something about the justice system. The police thana records will only, recognize physical violence, mob violence, destruction of property. And when you go to the appeal court level, it's very interesting. The only cases you find are murder cases or killings. So even the physical violence and destruction of property, mob violence, dislocation, forced dislocation from villages are not, do not find any legal redress. The only thing that what we found in a bunch of cases, entire data set from pre-independence to 2012, what we found was the entire body of appeal cases pertained to killings and death. And 50% of those were convicted, 50% of those found acquittals, and then from the remaining which were convicted, the appeals arose from convictions of accused. So what's interesting, it tells us, is that the prosecution does not ever appeal against acquittals. It's only the accused who will use the legal machinery at their own cost and go into appeal. So the state is not giving full protection to victims. So that's something. And then in the appeal cases, we found that most of the cases were ultimately either reduced on, given lesser charges or acquitted because of poor investigation. And very frequently we have judges in judgments saying that, bemoaning the poor quality of investigation. So I think that is certainly an area which can determine inclusivity or exclusion for those who want to access the legal system. And the third example, I think, will pertain to everybody in South Asia and is very pertinent when we looked at, because the debates on child marriage laws are so vibrant and so fiery in our countries, we all want to do something about it. When we looked at our 3 studies which were undertaken on early and child marriage, what we found is prosecution is carried out not just under the child marriage law. They use habeas corpus, criminal provisions on rape and kidnapping, kidnapping for the purposes of marriage, and so on. 65% of all the cases that we documented pertain to elopements, parents prosecuting daughters who are eloping. The state machinery to prosecute arranged and forced marriages is missing in action. And so when we have conversations about making the law stronger, we can only imagine the use of justice system to harm girls, not to assist and help girls. So I think that was a very important lesson. The other thing, what we therefore figured as part of the many consultations we've had, not just in India, but in South Asia and beyond, is that maybe we need to imagine laws differently. We need to imagine laws that give benefits to girls and women. We need to reimagine justice in terms of compensation, in terms of making welfare provisions for housing, welfare provisions for education, for food and nutrition, for employment, so that the entire criminal justice system, that is the only recourse which is focused on punishing an accused, is not the main sort of response for concerns that are much broader than that. And the other socio-economic aspect that we've discovered through our research is the entire body of child marriage cases concerns poor people, poor populations. This is driven by poverty. It is not that much driven by custom, because you have middle class and the more elite who are as embedded in customary practices, but that's we don't see that volume of cases from there. And we also found in our rape trial study, that people who access the justice system are all largely from poorer populations. So where are the middle class women going? Because rape is a universal problem. It is not just a class problem. So I think those are the things that I feel research, social-legal research, is a very important tool the judiciary has, which can be institutionalized to track, monitor, and understand the social realities, the justice needs, which are broader than what current laws provide, as well as the
Ms. Madhumera, I will just interrupt.
Thank you.
You can conclude within 1 minute, please.
Thank you.
Okay, thank you so much. In fact, we have paucity of time, and everybody is given 6 to 8 minutes. My next question is to Ms. Kumrom Nahar, and it's the same question in fact. How have the current legal frameworks in Bangladesh impacted inclusivity within judiciary, and what specific reforms do you believe are necessary to enhance these frameworks further? Next, can you share examples of successful structural interventions in the country's judiciary or institutional capacities that have significantly improved inclusivity? Additionally, what challenges have you faced in implementing these interventions, if you ever have been in that capacity, and how have you addressed the needs for mindset changes within these frameworks? Thank you. Over to you, Ms. Nahar.
Thank you.
You have 6 to 8 minutes.
My internet feed shows that it's unstable. Am I? Yes.
We can hear you.
Okay. Thank you, and thank you very much, all the organizers and all the guests. I'm very much honored to be part of the symposium. I was supposed to be there, but unfortunately, for my personal problem, I am not there. Thank you, and good day from Bangladesh. Actually, our constitution, you may know, Madhu Mehra, what she mentioned, similar to us. Similar, the situation is similar, and as you know, that the constitution of Bangladesh guarantees equality before law for all its citizens, and especially there is the provision mentioned under section 28 by subsection 2 that women shall have equal rights with men in all sphere of state or the public life. And the constitution, however, omits the mentioned equal rights in private life, therefore subjecting the citizens of Bangladesh to seek rights in private life under personal laws. Personal laws in Bangladesh are governed by codified religious laws, such as that set out under Islam and Muslim, Islam for Muslims, women and men, and so on. The Constitution omission constitutes to have far-reaching implication on women's rights in the personal domain, since religious laws as codified in Bangladesh Constitution, and as we seen in the section legal frameworks of women's rights, a number of laws have been promulgated to address this lacuna in this constitution. And unfortunately, Bangladesh has in the condition of the context of gender inequality and violence faced by women and girls, and as a result of vibrant and persistence activism by women and human rights activists enacted a number of laws upholding rights related to women and girls. However, not all law benefits women for protect their rights. Neither do all women benefit from nor they able to protect their rights under law, access to resources, and the justice system. Attitudes of police, judiciary, lawyers, including the socio-economic background of women, have a bearing on extent they are able to benefit from the laws upholding women's rights. I am happy to share that there are numerous judicial initiatives are favorable to women, like we have enacted the Domestic Violence Prevention and Protection Law in 2010. There are near about 30 laws which is favorable to women, and women's groups have filed public interest petitions that have received favorable judgment and orders by the High Court, such as the two-finger test. You may know for the rape victims, it's a mandatory test. The two-finger test have banned, and there are so many coalitions where different women's groups and human rights groups, they are in a coalitions. We are advocating advocacy for law reform, and we are also trying to reform our legal systems. And we have a special law which is implemented that specially protect women and children. This law helps ensure their safety and rights. In every district, we have special tribunal under this special law, and that is the court has have been set up and to handle cases of violence against women and children. This court was faster to give justice. There are also we have reform our medical legal examination systems. We have mandatory DNA tests in case of rape. DNA tests are now mandatory, and this helps in ensuring that the right person in punished. Also, recently in 2022, the Evidence Act, it's a long old law. It has amendment. The Evidence Act has been updated to make it easier to present proof in court. Now the correct evidence is not just of women. So and also camera trial are now allowed. So these are the positive initiatives we have in our legal system. The government has developed various policies relevant to human rights and their advancements, like we have National Plan of Actions Against Sexual Abuse and Exploitation of Children, National Action Plan. These are the positive initiatives. Also, we have focused on institutional capacities. Those are building strong institutional institutions is crucial for those are crucial for inclusivity. A number of NGOs with a strong presence in the local community, collecting statistics of violence against women and their field work in specific program interventions such as legal services, works with adolescents, awareness raising, and so on. And within the long activity within NGOs, women's organizations, and human rights organizations, there are lots of institutional reforms also happened. Like two examples are capacity buildings of lawyers and bar council, which was very much important for getting the justice system. So training programs have been started. This helps to understand and handle cases of violence more effectively. There are also women's cells have set up in police station, victim support centers have set up, access to legal justice, and there is a legal aid law we have also. And within government initiative, 12 ministry, including women ministry headed, there are initiatives of multi-sectoral programs on violence against women. Under these programs, there are one-stop crisis centers, and that have been set up district and sub-district level. Near about 80 centers are now running, and these centers provide all necessary service to victims under one roof. And these are significant example which is happened due to women's movement, human rights activists continuing advocacy. These are. But when we are talking about changing the mindset, actually, despite these all strong points, there are the prejudice of fear of police and lack of accountability, resulting in the making the law non-effective for the violence victim. And also the prejudice and that stigma, sexually abused and raped women and girls face social ostracism as women's honor is closely tied with preserving the family honor, especially that of the young. This is the same scenario in our context. And so the people is not coming to the justice system timely. And this resulting creating FIR delayed, investigation problematic, evidence collection is there are many problems arising. And also the social service providers, their mindset, they are not pro-women. So we are working we were working for the mindset so that they can handle and treat the victim with respect and dignity. And I can share with you one our example, Nari Pakho, so women activist organizations, and we are working with police, lawyers, and doctors, because these three organizations is closely working for the implementation of the law. But we have law, policies, and everything, but the implementation level is so poor. So we are trying to developing the implementation side. And Dr. Police, so like for police, we have developed interpersonal communication skills. They have law, they have all systems, but they don't know how to deal with the victim with respect. So they are the positive is the department is accepting us, and they are seeking assistance from us. And also the judicial systems, our judicial academy has set up, and the judicial academy is trying to they have included the gender and sensitivity and women's rights things in their training sessions. And also the women's rights and human rights organization, they are part of that, and we are working together collaboratively so that new judges they can be sensitized on women and so on. And also in our country, the NGO and civil society organization have there is a gap for statistics data, and incidents of violence reporting system is not in line. So over the years, we have grouped and regrouped as incidents of violence have been reported, and the women's movements have learned to strategize from network alliances and find a way to work with the government machineries to improve the accountability and deliver the services and bring policy and legislative change. As acid, before 2002, the acid crime was so high, and nowadays the acid crime has prevented, law has enacted, so on. And also there is the initiatives in line with the CEDAW mandate. There are a group, we are submitting a shadow report with the government and beside the government. So through this process, we are monitoring all the initiatives, and we are collecting data, and we are trying to focusing on the concerned area, like how to what will help the agencies to more effectively assess the applications of laws and impact on the women. And also these coalitions and I can say about the rape law reform coalition is looking after the definitions of law, because the definitions sometimes is a very problematic, but we are not so successful over the year, but we are trying. It is a long, deep-rooted mindset of even everywhere in the service providers, but in the values, attitude, and practice that undermine the right. The growing culture of immunity regarding violence, not only against women but almost all forms of violence, is a serious impediment to uphold the rule of law and protecting human rights. And also, there are corruption within the law enforcing agencies, judiciary, and medical practitioners often constitutes the formidable barrier to women, girls, and those disadvantages from accessing and seeking justice. In spite of all this situation, human rights organizations, women's organizations, NGOs, along with the related departments of the government, continue to support and protect women and girls, as victims of violence. Experience shows that individuals within the corrupt systems are committed to upholding justice and rights, and alliance form with such individual works in the interest of women and girls. And it is time to work for women's movement and civil society to work in solidarity and with the government to change not only laws and regulations, but to practice respect of human rights for women's rights and human rights. And all the department, there is a lack of coordination. So this should be, we are working on that. Also, many organizations are working, our development partners also with us. So we hope that we will
Ms. Cameron, can I please interrupt?
Yeah.
If you could please.
Yes, I am done.
Conclude in within 1 minute, please. Thank you. She is done.
Thank you
So much, Ms. Cameron. Moving forward, we have little time left. I'm afraid that we could conclude our discussion. My next question is to Justice Alia Neelam. What should we do to attract women towards judiciary, and how we make the system more inclusive? Or you can speak about anything you have brought for us. Thank you, madam. Over to you.
The women of Pakistan constitute around 51% of our population. But the question arises of whether this majority population has the requisite visibility and status in all the spheres of national life as per its ratio to population in the country. Then comes the question to the inclusivity of women in the judicial system. National progress is impossible without addressing this issue because the majority of the population cannot be ignored when it comes to national progress and development. Having said this, it is very important to examine and implement plans to ensure that our judicial system caters to such a huge population through a truly inclusive and...
We need a little silence in the hall, please.
Gender diversity requires that women and men be given the same opportunities such as access to resources, promotions, elevation to the superior judiciary, and so on. In Punjab, there are 36 honorable judges of the Lahore High Court, and presently I am the only female judge there. The most astonishing fact is that no female judge has ever been elevated from District Judiciary Punjab to Lahore High Court Lahore. The reason is that female women are underrepresented in the District Judiciary Punjab, and the mechanism based on seniority never enables the system to consider names of female district and session judges for elevation to the High Court. Presently, there are 7 female district and session judges, and their seniority starts from number 26 and goes to 153. Female judges with their various abilities and experiences offer a diverse perspective that is invaluable in the complex task of administering justice. The inclusion in the superior judiciary would not only address the gender disparity but also enrich the decision-making process. It goes without saying that in certain areas of the administration of justice, female judges can perform much better. In our society where females are given limited opportunities to grow, resulting in less contribution by them in all walks of life, of which law is not exception. However, against all the odds, until the prerequisites of judgeship are met, any female nomination from the bar may not be successful for such a position. The prerequisite of the practical experience gained through the active practice of law. For this, all the chambers, through respective bar councils, should be bound to have at least 30% female lawyers as their assistants, who must be assigned protective cases. Similarly, a panel of lawyers must also include 33% of female lawyers in government and semi-government institutions. This will substantially help them gain the required competency and produce experience essential for consideration for such nomination. Most importantly, the seniority list of female judges should be separately prepared in district judiciary to consider their elevation as High Court judges. The question of diversity and merit is non-conflicting. A minimum threshold of competence and merit can always be ensured through giving way to inclusivity. Electronic and print media can play a crucial role to influence public perceptions and raises awareness. Media houses should also be sensitized through media regulators to positively portray women in the justice system by highlighting their achievements and contributions. International best practices with high level of gender exclusivity of women in the justice system can be adopted. Furthermore, partnerships can be formed with international organizations to gain insight and support for gender inclusive reforms. Sir, this is all in continuation of your keynote address. These are some suggestions which I have bring today. If we follow all this, then we can bring women in our judicial system. Thank you.
Thank you so much, Justice Alia Neelam. Taking the advantage of your presence, I just want to correct the record. A civil judge in Punjab is not working for 15 or 16 years, as Justice Shah just referred, but we have judges, civil judges working for the last 22 years. मैं सिर्फ ये कहना चाहती हूँ हमारा कसूर क्या है, why we are not looked at, why we are not visible, and why the new people are brought to system. We are not against that the new people come to system, new blood should come, but who will be think for us for 22 years in a one cadre? That is really serious. Sir, and I want to let you know, ma'am.
Sir, first lady civil judge system में आई थी 1989 में, the first judge, civil judge. पहली खातून जज जो हमारे सिविल सिस्टम डिस्ट्रिक्ट जुडिशरी में आई वो 1989 में आई थी, और उसके बाद ये सिस्टम शुरू हुआ, मगर अभी तक हमारी जो जजेस हैं उनकी प्रमोशन का क्राइटेरिया वो नहीं है जो बाकी प्रोविंसेस में है, तो उनका एक्सपीरियंस ज़्यादा है इंस्टेड ऑफ अदर प्रोविंस सिविल जजेस, मगर इनको मौका नहीं मिलता आगे आने के लिए, इसलिए इनकी तमाम की सीनियरिटी लिस्ट सेपरेट जो सी है प्रिपेयर होनी चाहिए ताकि इनके नाम आगे कंसीडर किए जा सकें, एंड देन वी कैन गेट अ वेरी गुड नंबर ऑफ जजेस इन हायर जुडिशरी.
So I leave my question with the senior pioneer judge of Supreme Court of Pakistan, and moving next to Ms. Fawzia Waqar. What are the positive measures taken in Pakistan and elsewhere, because you have been working in different capacities in different countries, for increased inclusion of women and their duties and their issues in legal frameworks, institutional capacities, changing the mindset? And my next question would be, what are the things at and what needs to be done to address the legal, institutional and implementational challenges?
Thank you very much for the opportunity. Actually, I have nothing new to say. This is my disclaimer because everything's been said and it's been said very, very well. I guess my only observation is, why is it not being done? It's not about what is the problem, it is not about what needs to be done also, but why is it not being done? And I would really place it only at the fact that women are considered a low priority. While it sounds like rhetoric, it sounds very cliched, but that is your problem. Women and their issues are not a priority still. We have therefore, despite excellent constitutional guarantees, despite a tremendous legal framework which provides protections to women, various kinds of protections to women, asks for their representation, sets quotas for them, provides for enabling environment. Despite all of those, nothing is really being done. And for that, I just want to take you all back from judiciary into the society from which the judges come. Because the society, the way it is, what it is doing to its women, does the same to its judges also. Hence, just want to share a quick statistic, or rather a quick indicator or index, which is the Global Gender Gap Index. Much talked about, much criticized also, but we have nothing better as a national composite index to remind us where our women stand. And let me tell you that the Global Gender Gap Index of 2024 tells you that Pakistan has slid even further from last year in terms of economic empowerment, in terms of political empowerment, in terms of health, and in terms of educational attainment as well. But where we are doing the worst is women's economic empowerment. And we are doing the worst not only in the region of South Asia, but also in the world, is because our labor force participation is low, because our women in decision-making positions are very low. This is essentially what everybody's been talking about. We also have had very good laws, but that has not reflected in the result, in the outcome. So I will just take everyone back to what can we do. What we have done is great, and I guess a minute on what has been done, which is apart from the various laws like the Anti-Rape Trial and Investigation Act, which promotes an inclusive environment, or rather a respectful and gender-sensitive environment for the woman victim, to gender-based violence courts, which are institutional structures, to the guidelines that I'm very happy to be reminded were passed under Justice Shah's leadership in 2016 for the gender-based violence courts, and which have everything which now has legal cover under the Anti-Rape Trial and Investigation Act. We have other laws like Fair Representation of Women Act in Punjab, for instance, which is a very good example, which is a very good guideline, I'd say, for the other provinces which haven't passed it. Essentially, the law says that there shall be at least 33% representation of women in all the boards, committees, and task forces of the government. Quotas have been talked about: 10% in the federal government, 15% in Punjab, and 10 to 15% in various provinces. So the structure is there, the legal framework is there, the capacities are being built, etc., but it's not being done. Why is it not being done? And I guess my answer lies in 2 or 3 things. One is lack of implementation. Lack of implementation is glossed over as rhetoric or as something which is a catch-all phrase. It is not. Lack of implementation reflects in, are you monitoring? Is somebody monitoring that all these quotas that were set, they are being met? I'll tell you, for example, that in the justice system, despite the 10% federal, 15% provincial quota, not just the judiciary is lower in numbers, at all levels we are talking about. The police stands at just having about 1% women in its workforce. The prosecutors are less than that, 15% in Punjab or 10% in the country. The law, I'm sorry, I'm a little all over the place, but you're very sharp minds, you're going to connect all of these things yourself, which I can't because I don't have the time. So when the anti-rape trial investigation says that a woman police officer or a woman police person is going to take the statement of a woman, that links with the quota that the government has set. That links with the representation of women also. Why are we just thinking in silos and not connecting all these laws and ultimately using that to hold the persons accountable for not ensuring that there are 10% or 15% women at least, certainly not at the most, we have to make sure that the judge, whatever has been given in the law is being implemented, etc. So we need to focus on implementation, and within implementation, I just want to remind everyone, it's not the input that matters anymore. It is the output. It is absolutely what happened in result. The numbers that I've showed you is despite the constitutional guarantees, despite that we tout our performance in CEDAW, which is the Convention for Elimination of All Forms of Discrimination Against Women, the ILO conventions, which are very nicely cited in our Superior Court judgments, etc. So we need to understand, if we are coming out with the 20% labor force participation, with 13% financial inclusion of women, why is it that? And then hold someone accountable. And I hope that leadership, which is my next order of business, is going to do that. Leadership is fundamental, and I just want to remind everyone that leadership is not only important at strategic level, but everyday leadership counts. If I see a panel with men only, why am I, as a man and as a woman, not asking where the women are? If there is a committee, and we've talked about it, and there are various committees which have been talked about, why am I not asking? It is my responsibility as a leader to ask this question and to make sure that they are there. We are not doing that on a daily basis. That is your only fundamental problem also. Intent versus impact. I'm quickly throwing concepts at you. A lot of people are very well intended. They respect women, and I dislike the word respect because it masks all of the things that you will not do because you respect women, right? So they respect women, but they will not see what is the outcome of that, what is the impact of your respect having. And just to make it easier to understand, I respect women, but I'm not hiring them. So the outcome or the impact is that you're ultimately not measuring up. So please focus on in leadership, and I'm no disrespect to the current leadership sitting here, because you've done a lot and I think have been pioneers. And I'm really grateful for all the work that this leadership has done. But everyday leadership is what I want to emphasize on. Within that, I also want to address harassment which emanates from sexism. Casual sexism is internalized, it is institutionalized. When we ask question while recruiting a judge of superior judiciary, are you married? That is institutional sexism, which is still seen as a casual question, That is not permissible. Why don't we set ourselves why don't we make ourselves accountable to all the policies and all the commitments that we have made? So just please ask this question to yourself and to the committee. Why was this question asked? And never ask it again. Do not allow it also. And finally, in terms of judges, when you're promoting judges, I'm so grateful that the senior peony judge talked about merit-based promotions. Please assess judges on the basis of their performance. It should no longer be about time-bound delay reductions. It should, and well, it is part of it. It should not be just about disposal-based performance evaluation. It should also be about the quality of judgments that you judges are writing, because of the fact that these judgments are what will perpetuate the sexism, the harassment, the inferiority of a 49% gender, and that will impact the judges and their recruitment, retention and promotion, all of it. To end it all, I would just take the liberty of reading a 2021 judgment without taking names, which is briefly, and I quote, "A little doll in 6th year of her blossom was quite happy to find her in a school for education. After about a month of admission, her image in an evil eye roasted the lust one day, turned a human being into a Satan who grabbed the opportunity to catch her prey on 12/5/2017 at a certain time. She was put in the washroom of X school. The sex monger put him into action, unchastened the little girl. Modesty was intervened," etc., etc. Now, apart from my serious issue with the language used in this, which makes no sense to me, frankly, just as, in terms of pure language, this concept, this whole emphasis on chastity, modesty, honor, this reinforces the woman's responsibility to uphold all of that, and the security of that person and the dignity of that person is not emphasized. We are shifting the blame, well, not that, we are shifting the focus on all of these concepts which take away from the fundamental right to security of a person and the dignity of a person. Thank you very much.
Thank you so much, Ms. Fawzia Bakar, for keeping up the time. My next question is to Ms. Vadia. What mindset changes are required at legal and institutional framework to foster inclusivity? And you have also 6 to 8 minutes to conclude. Thank you.
Thank you. Thank you, Shazia, for providing me an opportunity. And I would take the key point of Ms. Fawzia as she says that you empower leaders and the system will be empowered as well. So from exclusion to embrace, there is an impact of mindset shift. And this all is a change, and change is a process. Even that maybe is a gender inclusivity or diversity, that all acts as a catalyst towards that change. We have come to the point that from awareness to acceptance, from adoption to sustainability, we have acknowledged that women, individual recognition, her right to self-actualization, her financial independence, and her representation is crucial to socio-economic growth. So also for the members of marginalized groups and persons with special ability. And it is all because of growth mindset in our leadership. We have success stories that our growth mindset leaders have been making in judiciary as well. You can quote the examples of inclusivity efforts, and I'm once again thankful to Mr. Mansoor Shah Bukhari for acknowledging this fact that Peshawar High Court has been able to increase that number of women judges in KPK judiciary, yet we do have more leaders in our leadership positions as women judges. To point few, we have leaders and the women representation in Apex Court of Supreme Court of Pakistan, and one of them is from KPK. And then we had our women judge in Khyber Pakhtunkhwa Judicial Academy as a Director General. Out of 6 district and session judges, 4 of our judges are working in a hard-hit areas owing to geographical locations, and even these areas are prone to terrorism as well. Yet they are all working in the area owing to a supportive atmosphere at workplace. So we have success stories, but when we talk about in collectivity, there is a flip side to a coin as well. Having that 10% of fixed quota at induction level, we have been able to increase the number of judges to 16% in Pakistan. But then there is a bottleneck, as you had hinted. If we talk about Punjab, there are civil judges that are working for more than 20 years and they are not getting promotion. Then we do have members of district judiciary. When we talk about inclusivity, that means we also talk about our men judges as well. We talk about each and everyone's representation. If that is about district judiciary, that is required to be represented through elevation or through any system, through any policy intervention at high court level, that at leadership level our representation is lacking. And if a judicial officer, whoever enters in a civil service that aspires to become a judge of high court, but soon when that person enters in judiciary, a realization comes to the fact that you will be ending as a district or session judge at the most. But there are judges in Punjab, and there will be judges in times to come if there is a bottleneck, that you will be ended up as an additional district and sessions judge. Sir, you have spoken our heart out. We will not be able to point out that all that was said in gray lines, but when it's said in black and white, it means that there is required a preference owing to Article 25(3) in the Constitution, that now in 76 years of independence of Pakistan, there comes a time when, apart from representation in quota basis, apart from allowing women to appear in competitive exams, let there be a sifting, so that leader that is able, that can come up, because it's a service delivery profession, you have to compete, and then everything is possible with a supportive atmosphere. I would quote here an author that she's Sheryl Sandberg, and in her book, Lean In, Women, Work and Will to Lead, she writes that women need to shift their thinking from, I'm not ready to do that, to that thinking that I will do it, and by doing that, I will learn out of it. There is another thing that is very important while working as a women judge. I had felt myself that this growth mindset at leadership level is pivotal to combat structural biases as well. Biologically, as women, we are different. We, as women, we procreate. We have our monthly menstrual cycles, and under the mindset of that formal equality and structural barriers, we sit and serve during our working hours tirelessly, not expecting to leave our places till the prayer break. We all would bear out that our job nature is such that once we get into our work, we get so much engrossed and involved that we even forget everything else, even the slightest health break. We have the instances of modern developed world where if a judge or a prosecutor decides a vulnerable case, a case that affects him vicariously, he is given a health break so that he can come out of that vicarious trauma. There are well-being trainings where you can impart those skills to a judicial officer, that how he will be healing his own self. But there are times when you need to consult someone so that you can progress career-wise in a profession that is very challenging. Here I would share a research from National Birth Defects Prevention Study carried by New York State Department of Health and Innovation back in 2009. It was found that there was an increased rate of birth defects and even infertility owing to maternal occupation or the occupational exposures to vicarious trauma and excessive release of cortisol generating into oxidative stress. There is no published statistical data or an empirical research on that, but if I urge to the leadership that if it is being carried out, it will confirm cases of children born with autism, children born with genital defects, with premature births, and there has not been any well-being policy intervention at institutional level, where a pregnant worker would be taken care of at least in the first trimester of her gestational period, which is a collective responsibility requiring a mindset change in our leadership system. We have supportive environment to avoid that sifting of women at leadership level. Even at home or at workplace, a woman is fighting at two fronts. It sips out her energy, and at the end, many a times I've seen in our even profession, the women are being sidelined, or they do not take the lead in terms of administrative work owing to gender type stereotype roles. This is a gender stereo role at home that during parenting often parenting lapses are attributed to a woman by saying, oh, ye to apni maa par gaya hai. And when it comes to carrying that hat of success, it's all said, he carries my name, and it's because blood runs in his veins that he carries of mine. There is a requirement, although it has nothing to do with our judicial leadership, yet through gender sensitization and through change of perspective, we can contribute our role from shift to helping at our home to contributing our role at home, and then even at workplace, where in many discussions there have been those highlighted structural barriers that give a setback to a woman to come into the lead. And at the end, I would just add a spice to our discussion out of two stanzas from a poem, and it says in the tapestry of equality, let not prejudice tarnish the human heart, for we are all united through worlds apart. Hand in hand, let us break free from chain, embracing diversity, in unity we gain. Injustice shadow we vow to defy, with voices resilient that rise to sky. For strength of our cause, unwavering and just, inequality's shackles will crumble to dust. Thank you.
Thank you so much, Ms. Vadia. The topic is closer to all the hearts who are present here. So I will conclude, system must realize that some policy framework should be introduced at all tiers for our structures. I, a civil judge for 16 years, and many more seniors to me civil judges sitting around there with 22 years of experience, must have come to the system with many dreams. They might have changed something more. They might have been one more Justice Aisha. They might have changed the mindset, but let them come ahead. Let us work more. Thank you so much. I request Mr. Fakhr Zaman for the takeaways within 1.5 minute, if you could. Thank you.
Ladies and gentlemen, I am in a great fix. If I am asked to define perfection in 1 minute, in one word, I would say smash. Sayyid Mansoor Ali Shah. And I'm in a fix because this session contains a keynote address by Justice Mansoor Ali Shah, and I am extremely fixed because I cannot distill, I cannot take any word of that out of that. But still I have tried to get something, some distilled wisdom from that. And for today's takeaway, I have enhancing judicial legal frameworks. There is a need for robust legal frameworks that support meaningful inclusivity, ensure career progression, and overcoming structural barriers. Next is building institutional capabilities. There is need for equitable resource allocation to strengthen institutional capabilities for fostering inclusive justice. Networks and visibility. There is need for ensuring that women have a voice in policy making. Infrastructural support. There is need for hardcore brick and mortar augmentation for ensuring gender responsive environment. And changing mindsets. There is necessity of cultural and mindset shifts within the judiciary and broader society to foster a more inclusive environment. And lastly, learning from regional practices. We are to replicate insights from Maldivian, Indian, and Bangladeshi experiences on implementing effective structural intervention for inclusivity. Thank you very much.
May I have your attention, please? Ladies and gentlemen, may I have your attention, please? हमने चीफ जस्टिस साहब को टाइम दिया हुआ है, हमें अपना सेशन कंक्लूड करना है उनके टाइम से पहले. कोई मेरी बात सुन रहा है? शाह साहब को मैं क्या कहूँ? Ensuring inclusivity through capacity building, our last session. I am inviting the moderator of this session, Mr. Muhammad Amir Munir, faculty member FJ. Mr. Muhammad Amir Munir, additional district and session judge, is currently the director of research and publication at the Federal Judicial Academy and is a fellow of the Commonwealth Judicial Education Institute. And with 24 years of judicial experience, he has published extensively on law and development, authored a book on law moods, and contributed to numerous international conferences. He is also a co-recipient of the Jones Hora International Judicial Award and has served in various academic and advisory roles. Mr. Amir, can you please join us on the stage to moderate the next session? Next session is over to Sir Amir.
Thank you very much, ma'am, for inviting me to this session as a moderator. And I have also told that I may be speaking something on the topic as well, if I got the time. So we have now, in this session 4, the main topic of our session is ensuring inclusivity through capacity building. And we have now 5 panelists. I will invite one by one by mentioning their brief biodatas so that you all can know that what they are. So first of all, we have Justice Ms. Shirani Tilaka Vardhane, She is a former Judge Supreme Court of Sri Lanka, and Justice Shirani presently is a consultant to the Sri Lankan Judges Institute, an international and national arbitrator and an international accredited mediator to the Singapore International Mediation Institute. She is also a judicial educator in many parts of the world. She serves on several organizations as a consultant to the UNDP, UNODC, ILO, ICJ, and continues to work as a consultant, expert advisor, and panelist with organizations such as Legal Action Worldwide, and is presently on the advisory board of the ASEAN Judicial Integrity Network. She is the deputy chair of the Judicial Integrity Group and presently involved with drafting of the amendments to the Bangalore Principles and the commentaries on it. She is also on the International Advisory Board of the National Committee of the State Court, NCSC, of the United States of America. She also continues to work with Judicial Integrity Network, a global body affiliated with UNODC. She was an international consultant to the United Nations Development Programme, UNDP, in the Strengthening Transparency and Code of Ethics for Enhanced Public Confidence in Court of Cassation in Turkey project. Justice Tilaka Vardhane was the first female state counsel in Sri Lanka in 1978. The first female judge of the High Court, first women Admiralty Court judge, first women justice of Court of Appeal, and the first women president of the Court of Appeal in 2003. She ascended to the Supreme Court of Sri Lanka and served as Supreme Court Justice for many years and was also an acting Chief Justice. She holds 2 honorary doctorates in law from Smith College and Williams College in the United States of America. She also has a diploma in forensic medicine from the University of Sri Lanka. Justice Tilaka Vardhane has received many awards including Sakshi of India Award and the International Zonta Award. She is a fellow of the Commonwealth Judicial Education Institute. I am feeling proud that I am also a fellow, and my another fellow is now with us from Sri Lanka. Justice Tilaka Vardhane has served as an attorney in the District Attorney's Office of Colorado, in Fort Collins and Greeley in the United States. She was an advisory board member for the International Center for Ethics, Justice and Public Life of Brandeis University, South Africa, and a member of the International Panel of Jurists of the International Bureau for Child Rights with United Nations affiliation. She has helped draft SARC protocol on trafficking of men, women, and children, and initial guidelines for the child witness testimony for adoption in the ICC. She has worked with the Council of Europe on cyber crimes against children in terms of Budapest Convention and Lanzarote Conventions. She lectures on AI, artificial intelligence, generative AI, ChatGPT, ChatGPT-4, Midjourney 5, and Sora, the latest AI platform. So we welcome Justice Tilaka Vardhane, and she is available with us on Zoom. So has she joined on the Zoom?
Yes, I think I have joined. Can you hear me?
Yes, thank you. We can hear you.
Thank you, fellow alumni of the Commonwealth Institute.
Now I invite our next panelist. She is Ms. Marwa Khan Cheema. Marwa Khan is an assistant professor at the Sheikh Ahmed Hassan School of Law, Lahore University of Management Sciences. She completed her BA LLB from LUMS and LLM from Harvard Law School on the Fulbright Scholarship. She is the co-founder of the Pakistani Feminist Judgment Project and the founding member of the co-editor of the LUMS Law Journal. Marwa's research and teaching focus involves constitutional law, human rights, and gender. Some of the law electives she has designed at LUMS include expression confined, constitutionalization of gender in Pakistan, asking feminist questions in Pakistani courts, and gender advocacy clinic, the practice and research of gender rights. Ms. Marwa Khan. Ji, welcome. Now I invite the third panelist, Ms. Munazza Hassan Nasir from Lahore School of Economics. Munazza Hassan Nasir is a senior teaching fellow at the Lahore School of Economics. She has an MPhil in linguistics from Kennedy College for Women. Munazza Hassan Nasir advocates for equity and social justice, with her research work focusing on language and gender dynamics. She earned recognition of her analysis of gender representation in Urdu textbooks presented at Harvard and Oxford universities. Through her work, she wants to create awareness about overlooked issues of women, such as honor killing and many other embedded in language. Her pursuit of justice and equality continues to drive her academic endeavors, and she continues her work that revolves around women and social issues. Welcome, ma'am. Our fourth panelist is Dr. Sadaf Aziz. She will be with us on Zoom. Dr. Sadaf Aziz joined the Department of Law and Policy as an assistant professor and was amongst the small cohort of faculty who launched the BA LLB program here at LUMS. She designed the first labor law and jurisprudence courses for the program and pioneered field research-based courses such as law and social justice. She completed her PhD in law from University of Melbourne in 2020. Dr. Aziz's research interests are in the areas of legal and political theory and the comparative and historical study of legal regimes in the subcontinent. A contextual analysis as part of the highly acclaimed constitutional systems of the world series, and has published articles and chapters focused on gender and constitutionalism, constitutional foundations and interface of liberal and non-liberal legal orders. Currently, she is revising a second book manuscript in re-investigating early Pakistani state. Dr. Aziz continues to contribute to projects and reports addressing arbitrary policing, miscarriages of justice, and the use of capital punishment in Pakistan. She is dedicated to curricular innovations and in ensuring that students are equipped with the tools to engage with the justice system with a view to addressing and ameliorating systematic inequalities. So we welcome Dr. Sadaf Aziz on Zoom. Is she with us? Dr. Sadaf Aziz, can you hear me?
Yes, I'm here. I'm not sure my video, why it's not showing, but I am here. Can you hear me?
Yes, I can hear you. Thank you very much to be here with us via technology. Okay. And our last panelist is Honorable Miss Justice Saman Rafat Imtiaz. Honorable Miss Justice Saman Rafat Imtiaz was born on 8th June 1976. She completed her O-levels in the year 1992 and A-levels in the year 1994 from Beacon House Public School, Karachi. She obtained her BBA degree in the year 1998 and from American University in Dubai, and secured her degree of Juris Doctor in the year 2001 from University of Richmond, Virginia, USA. Honorable Ms. Justice Saman Rafat Imtiaz started her career as a lawyer in the year 2004 and established her own law firm in 2011 in Karachi, specializing in corporate, commercial, banking, tax, and other civil matters. Her Honor took oath as an additional judge of Islamabad High Court on 17th December 2021. Please welcome Honorable Justice Saman Rafat Imtiaz. So to start the panel discussion, I will first of all ask Honorable Ms. Shirani Tilakavardhane from Sri Lanka that, ma'am, can you explain the impact of judicial education and training on empowering judges in Sri Lanka and how it continues to ensuring inclusive justice? Additionally, what lessons can other South Asian nations learn from Sri Lanka's experience in this area? Over to you, ma'am, and we have 6 minutes for your presentation.
Can you tell me whether you will be asking other questions? Or are you going to, do I do my entire presentation right now? Because I was told I will have 10 minutes or to 15 minutes.
Yes, initially the time was 10 minutes, but now we have, the earlier session was a little late, that's why we curtailed a few minutes. So you just start kindly.
Right.
Yeah.
So, good afternoon, everybody, and let me assure you right at the beginning that the type of inclusivity which we are talking about includes every aspect of humanity. That is, wherever there is discrimination, whether it's on age, whether it's on gender, whether it is on children, the race or caste or creed or religion or whatever it may be. This conference, I think, is addressing the holistic view of there not being discrimination on the basis that the Charter of Human Rights gives us the broadest of spectrum. It is the language, because it says that these rights of equality are universal, that it is inalienable and it's indivisible. Now, we have heard a plethora of things. I took part in the last session and I was amazed at the knowledge and the empowerment of that session itself. And something very important was said about leadership. Now, we're having a huge problem globally on leadership. Women have come in, and we have this leadership of women who are holding mid positions, but now there is a diamond ceiling, because now it is even worse to get from there to the head of that institution or into the upper echelons of the institution. So that is something, and it is up to the women themselves. And let me say this very clearly in the words of the Secretary of State, Madeleine Albright, where he said, a woman who does not help a woman, a woman who does not help a woman has a very special place in hell for them. So, can you give me the changing slides, please? I had it earlier, but you have... Okay, I haven't got it, but I'll use this. So, I'm just going to touch about the inclusive...
We are watching your slides, just please carry on.
Yeah, I just clicked it from here, but I couldn't click it on the PowerPoint, but it's okay, I'll manage it. So inclusive, we are talking about women, and it's this question of, we are somehow the checklist, the guidelines, the protocols, and the policy statements. As somebody said, we have it all, but there is no effective implementation of it at all. So this is we are talking of equal opportunities, and we are also talking of the contribution, the importance of it is the contribution of, and the well-being of communities, and it's going to add 12 trillion if 52% of the women can get into the workforce and can have even a mediocre removal of the discrimination that is against them. So we have, which we have to deal with when we are coming to the overall discrimination of all those who are being discriminated, workplace discrimination, lack of discrimination, social norms and stereotypes, and access to education. So when we are building with capacity building, as you know, education consists of three parts. It is, first is education, second is the tools and instruments that you give them, the acts, maybe these checklists and guidelines to be used. And we have to teach them how to use it, that capacity building of continuous education on equality, on human rights, on inclusivity must go on, and it must work on through people who are trained. We are going back and forth on this, and we are not really making it. So these are the barriers. I think it speaks 1,000 words. There have been some progress and initiatives. Now please, we need to know this in the background of what you are doing so that we don't repeat these programs on legislative reforms, education, and global movements. We now are trying to call it environmental justice, which is the larger impact, which has intra-generation and intergeneration for long-term sustainability. Now, these are denied in South Asia particularly due to patriarchal hierarchies. Now, let me talk, when I'm talking of patriarchy, I am not talking of a male model or a male, something special to males. Patriarchal head comes, as you know, and you have been told this all along, it's a construct, social construct comes out of and creates male privilege and entitlement and advantage, and then uses stereotypes on women because it has never been a female narrative that has been leading the individual and leads to collective disempowerment of men. So when we talk about patriarchal hierarchy, it's very important that we remember. We have all the international laws, we have the national laws, development of all these different instruments. Why is it that we are still having these stupid pronouncements coming from judges across the globe? It is not just to say, why are we having them? Mainly because the religion, the beliefs, the cultural traditions are insulated. It insulates that present judge who is giving that particular decision and blinds that judge through the assumptions that are made, which is their opinion. So capacity building must very importantly take over, is a process of taking out and putting in, and that is a I have done it for 40 years, and it's a very, very difficult thing to do. Then we need to deal with core values of equality, impartiality, and justice, which underlie the legal system. These values will be protected under statutes and case law, especially on sexual violence, sexuality, rape, sexual abuse, and sexual harassment. So one of the things, and this is very important in capacity building, to understand that gender performativity posits that gender is made of acts that mark a person as man or woman, the dress, the mannerism, etc., etc. And it's through the repetition of those gendered acts that the illusion of a stable gender identity is created. And under the human rights norms, we have in theory an equal protection of freedom. Does it work across the board for a collective population of women of the globe? The reality, it doesn't. Why? Because even in cases like rape and other things, and other than narrative of sex and gender that are informed and constructed through a strong law and legal system, is completely insulated by that, through that individual judges' beliefs, customs, tradition, culture. And these are social constructs, and these are variable dynamics. Let me tell you that now can you see these things? This was the culture, this was the belief. Butter is slippery, you can eat as much as possible, lubricate your arteries and veins. The smooth taste of expectant mothers crave. No flies, thank you, eat it. Can you see how these myths and stereotypes, which are linked to the supposed inferiority of men and the superiority of men and the inferiority of women, leads to a male structural dominance, based and underscored by explicit or implicit or unconscious bias and confirmation bias. So what we have to think about is how do we deconstruct and how do we build? Because it is about what should it be about? What should our lectures on capacity be about? It is about inequitable recognizing and deal with inequitable distribution of power dynamics and the resulting discrimination within unconscious, conscious, explicit or implicit life that we are dealing with. I wanted to start on a case which is really important and which will tell you these are the kind of tools we have to use. Judges are work very easily with this, work through the law. So this was a case where the accused was acquitted in the High Court by the Court of Appeal, and then it went to the Supreme Court, and it was before a woman judge. And it is strange that it seems most of the judicial decisions there are very good decisions by men, please don't let me demean the decisions, the overall decisions, but there are some things that just seem to pop out. And then Claire Leroux-Dubé said this, she said that stereotypical assumptions lie at the heart of what went wrong in this case. The specious, that's superficially plausible but actually wrong, defense of implied consent consent implied by law, as applied in this case, rests on the assumption that unless a woman protests or recedes, she would be deemed to consent. On appeal, the idea also surfaced that if a woman is not modestly dressed, she is deemed to consent. Such stereotypical assumptions find their roots in many cultures, including our own. They no longer, however, find a place in the Canadian law. I do wish we can one day say these myths and stereotypes through which the individual judge is working no longer finds a place in the South Asian law, however honestly that may be held. So I will go to, so there are a lot, one of the big problems in capacity building we have to remember is language. Language plays a strong role in legal discourse. This linguistic role supports the way power in law is communicated, from examining the language of police interviews to the language of the courtroom, from lawyers and witnesses to judges and juries. Research that instigates power dynamics in legal discourse has sought to highlight, ironically, patterns of discrimination embedded in the operationalization of the law. It is yet now, I'm just going to take, because this has to be understood and we have to deal with this incapacity building. So this is what one judge said: shameful incident, knowing and realizing the trauma, the humiliation and the embarrassment they will have to go through in society. What was the victim going to gain by making such a false complaint? Please don't put this kind, however well-meaning it is meant, because judicial observation on the shame, humiliation, embarrassment,
excuse me, ma'am,
attached to sexual violence,
I have to,
reflects
to
dominant social
interrupt.
perceptions.
Ma'am, I have to interrupt because we are short of time. Can you conclude in 1 minute, please?
Yes, I will. That is attached to sexual violence reflects dominant social perceptions regarding rape, where the victim often suffers an additional social burden in addition to the violence. Focus on the victim, not on the perpetrator. That is what is happening now. Social stigma, and the law is, the law, for instance, the evident ordinance says that in a rape case, the woman, the prosecuting was can be questioned if that she had a immoral character. But the whole of the rest of the law of evidence says no man can be questioned. And let me, so I'm going to just rush through this because I have been told. At a time when there is violent conflict and economic displacement in the world, and a changing climate are causing increased levels of uncertainty and fear around the world, authoritarian, non-democratic movements attempt to present themselves as an antidote to these concerns. Instead, we must have the highest standard, and we must only do it through the critical supports, and in doing it, we support critical examination of the rule of law, so that it must, and this such law must include every single woman of who are our sisters. Thank you, everybody. I'm sorry about the time. So much to say, but I think our time has been cut short. Okay, thank you.
Thank you, Justice Tilakavardhane. We are grateful and we have learned a lot from your experiences and the case law and everything you shared with us. Hopefully we will try to adopt something out of it. Now I will request my remaining panelists. Experience do you derive from it for the judges on issues of using regressive language at one side and incorporating social context whenever and wherever relevant? And can you also give us some examples of other jurisdictions for the judges and the lawyers sitting here to learn to improve the language of judgments and pleadings? Kindly take the maximum time, 5 minutes for this answer. Thank you. 8 minutes. So with the permission of the chair, 8 minutes.
Thank you so much, sir, for this extra allowance. So first of all, thank you for having me on such an esteemed panel in front of such distinguished an audience. The Feminist Judgment Project is something that's still ongoing and very much close to my heart. There's a series of feminist judgment projects going around the world, and Aruba Satar and I started the one on Pakistani feminist judgments, where one aspect of the project is to rewrite pre-existing Supreme Court judgments from a feminist perspective. The pivotal point that we are trying to project here is that the legal reform, which is often talked about, legislative reform is not the end all. We see various instances where very progressive legislation has come about, but it's not being adequately implemented within our judgments or from within the enforcement aspect. We also see that even with the existing lacuna or gaps that exist within the legal framework, a more feminist approach to interpreting law, even without judicial activism, can lead to more equitable outcomes. So for this, we are essentially looking at a couple of things. So number one, when we talk about feminism, we're not only talking about women, we're talking about all genders. Number two, we're talking also about linguistic, religious, ethnic, and other minorities and marginalized groups. Number three, we're also talking about the protection of the ecosystem overall. Secondly, one of the key factors to consider will number one be to contextualize what the law is, where the law is coming from. So looking at the historical approach, the political approach, and also the social context of the law and the case at hand. So I can give you examples of another thing that's close to my heart is post-colonial approach towards interpretation of law. Primarily because our legal system, even though at this point in time, most people view Pakistani law from an Islamic perspective, but that's not true. Much of our law was actually codified by the British. Much of our religious laws were actually also codified by the British, even to the extent of the initial provision on blasphemy law. That was something that the British introduced in the Indian Penal Code and was imported into the Pakistan Penal Code. So that notion is something that we first need to dispel. So a lot of regressive elements within our legal system, for example, depriving transgender persons and gender fluid people of this basic citizenship rights, things like restitution of conjugal rights, things like linking grave and sudden provocation and making it a justification for honor crimes. All of these things were actually brought in by the British. These are not things that are coming from Islamic law within our legal jurisprudence. So that is being cognizant of the origin, first of all, is very important. Much of our law is actually embedded in Victorian morality, which is not the real reflection of South Asian cultures. Secondly, another important pivotal point is to always ask the gender question. So some things can be very overt and in your face, like am I saying or writing something that is automatically placing one gender at a disadvantage? So for example, I'll just quote two judgments here very quickly. In Nathar Barni versus Federation of Pakistan, this is 1983 judgment by the Federal Shariat Court. While considering whether a woman is eligible to serve as a judge, the judgment repeatedly talks about how men are providers of women. What's the relevance of that would be the first question. Whether she is capable or not to serve as a judge is an entirely independent thing, unless you are saying that a woman is subservient to a man, in which case then she is not eligible. But that is thankfully not the outcome that they reach. In another case pertaining to surrogacy and whether it's legal or not, the Federal Shariat Court actually calls a woman an agricultural field and a man a farmer. It calls women sheep and men shepherds. So you don't really need to go that far to essentially sort of ascertain all of these things, right? So they even linked a child born with impairments through surrogacy as a poor taxi cab experience, which is a very, very sort of problematic language to use. But even apart from that, there are also a lot of other things that need to be considered. So I think Ms. Fawzia essentially mentioned in her talk about the element of respect, that we respect this person, so we are not going to allow her to be in this difficult situation, regardless of what you're sort of taking away the woman's agency. What does she want to do in that?
Ma'am, we have time limit. Kindly
yes, I'll wrap up in 2 minutes.
Thank you.
Yes, thank you so much. The other thing, of course, is that sometimes judges are looking for the perfect victim, and when that victim comes along, so for example, if you're looking at a child abuse case and the child is, so let's say, under 7, the judges will jump into speedy justice at the expense of due process of law. Many of those cases will not hold up in appeal. You're also essentially in violation of Articles 10 and 10A of the Constitution. But when the imperfect victim comes along, that's when very minor factors essentially are taken to discredit the victim. So if there's just like last 2 sentences, there's a very minor issue within her statement. Why was there a delay in filing an FIR, for instance, in the Mukhtar Mai's case? They didn't look at the fact that she was an uneducated woman who did not know the criminal justice system. They did not look at that she was actually standing against the same jirga that victimized her. They looked at, yes, there was a delay, and why would someone who was not already a virgin have problems with coming forward? And just on the question of comparative framework, so the Indian Supreme Court under the current Chief Justice has actually devised a book, and they worked with academics. There's a handbook on gender stereotypes, essentially, which is a very nice sort of succinct thing. And I do encourage our judges, now that I have the platform, to work on this essentially, because we also have some very progressive judgments coming forward, just much like this other physique judgment, ma'am. But we still feel that a lot of judges are essentially not paying attention to those progressive judgments. So I will end my note on that. Thank you.
Thank you very much for your insight. What I have learned as a judge is that I need to rewrite my own judgments to understand what is this perspective. So some old judgment I can take it and then I can rewrite it. So I think I can find out more gender perspective into it. This is how we learn. So we need to redo it. So again, I will request a time constraint for my remaining 2 panelists, with a request that somewhere time is allowed more, and from the other side I am said no, time is short. So we have to maintain a balance. Thank you. So now Ms. Munazza Hassan Nasir, keeping in view your expertise, I am to ask that what is the importance of language and how it impacts our decision making process. Number 2 is that what is the impact of biases into this language thing, which we have already learned from our homes, our streets, and from everywhere.
Okay,
and
I'll try to cover just the first one, because I don't think I have enough time for both the questions.
Okay, let me complete, then you can decide which side you are going to take.
All right.
So as a linguist, what can you tell us about the relevance of language in creating more inclusive environment for women in legal profession? So you may focus on this only within the next 4 minutes, not 5.
No, I won't. Okay, thank you so much. So I'll begin by saying that language is not just a means of communication, but it is a tool that shapes discourse and builds narratives. So when I say that Musamad Zainab was raped and the perpetrators were they were handed this punishment, you would be angry and you would think that, okay, so that he probably got 10 years of imprisonment. But when I say that 1-year-old Zainab Musamad was raped, then you're indignant, you're upset, and then you know that the judgment is also different. It means lifetime imprisonment. So that's how narrative is built through language. And language is so powerful that it can be used to dominate people. And Gramsci talks about it in detail. It's called discursive hegemony, where people can be controlled and dominated through words without using any physical power. Imagine controlling the world without any weapons. So language can do that. Yesterday, Justice Aisha Malik mentioned that we have chairman and ombudsman, etc. So these are the words which were coined hundreds of years ago when women were not chairpersons. So imagine someone who's a woman and you're calling her a chairman. So that you have to change. The only thing that is constant is change. So it's about time that everyone tries to accept that we need to change our language. Because now I want to focus on my research, which is, can you go to the next slide, please? So I conducted a research in 2019, and I wanted to find out about the gender representation
of women in Urdu textbooks that are used in Punjab government schools from grade 1 to 5. So there I found out the text was extremely biased, and women were depicted in roles which are very stereotypical roles, mothers and teachers, that's it. And the men were represented in 35 different professional roles, including doctors and lawyers and soldiers and so many more, right? So you see now, if you're thinking why we don't have women in the justice system, because when the child is just 4 years old, 5 years old, and throughout the child's educational experience, what this child is learning through the textbooks is that women are supposed to be mothers and teachers, whereas the other roles are reserved for men. So Sweden changed the curriculum 45 years ago, so it's not a coincidence that it ranks first in EU when it comes to gender equality index. So I feel that we need to change a lot to include women in the discourse of, just to include in the discourse and in this profession as well. Then I want to connect this to you. How is this research important? Because your judgments are like these textbooks. The young lawyers, the young judges, they're going to read these judgments over and over and over again, and they are going to stay with them for the lifetime, And so what you are doing is you are either going to just let the biases continue, these biases will be perpetuated, or you can bring about the change through your judgments, through the language that you use. So don't use phrases like not a virgin and habituated to sex, and something that Ms. Fawzia mentioned was a doll in her 6th year of blossom. Who talks like that anymore? Nobody talks like that anymore.
Okay, can we conclude now?
Okay, we want to conclude, okay. All right, so all I can say is, okay. So then, okay, so when this morning Justice Shah was speaking, so when he was speaking, and I just felt this enthusiasm, I could see that here is someone who wants to bring about a change and who's actually passionate about this cause. So I was thinking, okay, now, so I'm going to tell him that you should create a committee maybe who will keep a track, because we come here, I was here 5 years ago, we talk and we go back home and nothing really happens. So you need to keep a track, and he even named that organization, he calls it Diversity and Inclusion Department. So I think it's a brilliant idea and we should go ahead with it. And that was my last slide also. So I'm so sorry I couldn't convey everything that I wanted to convey. Thank you.
Ma'am, thank you very much. Actually, can you show the slide again?
Yeah, that was an important slide actually, the one with the table.
Thank you for your perspective, okay. And don't worry, whatever you have written, we will inshallah publish into some booklet, okay, and everything will be conveyed to everyone. Perfect. Everyone concerned, particularly the judges like us. So I want to, as you mentioned, there should be a connection between the things. So I have seen a connection in this story. So Amir दौड़ में दूसरे नंबर पे आया, तो Amir is my name. I don't know मैं दूसरे नंबर पे आया हूँ कि नहीं आया. Okay, Sadia is my sister, and let me connect with the whole thing. I don't know what is coincidence into this page. I have just seen it. Sadia is my sister who did her MPhil, and the topic of her thesis was appointment of women judges in Sharia. So she did something like that. I think she interviewed Honorable Justice Mansoor Ali Shah and maybe some other women judges here as well. So this is her connection, and Ahmed is my real brother. He did his PhD from McGill. The topic is Khula. So he critically evaluated the principles of Khula under Imam Abu Hanifa's principles. So I don't know what is this page. I will share with my family. Thank you. Thank you, ma'am. Thank you for all the perspectives and for controlling the time limits.
That's fine. Thank you.
Now the next panelist is Dr. Sadaf Aziz, who is with us through Zoom. So I will again request first about the time constraints and then ask the question to Dr. Sadaf Aziz. Yes. How do you describe the contextual analysis of the Constitution, particularly under the amended Article 25, which is meant to ensure equality before law and equal protection? flow. Okay. So can you explain, ma'am, what is your research on this point within the next 5 minutes? Thank you very much. We are unable to hear you, ma'am.
You can't hear me?
Oh yes, now it's okay. Please carry on.
Okay.
So 5 minutes and one question only.
Yes. You can hear me all right? Is that? Yes. Okay.
Yes,
Thank you, Justice Shirani. Yes. So I will. So in 5 minutes, and I have my eye on a watch right here. I will quickly try to go through some context. Obviously, it's very difficult in this. So let's just start. I mean, effectively, what I want to say is that the Pakistani judiciary has actually been quite remarkable insofar as how they have wedded protections that are provided constitutionally against gender discrimination and for equality with broader protections both derived from our principles of policy but also from other adjunct rights which are described within the main chapter of the Constitution. However, I just want to take us through some of the case law pertaining particularly to gender discrimination within the workforce to illustrate some of the lacuna. And the reason why I'm doing this is because beyond or in sort of in conformity with the arguments that have been presented and the evidence which has been presented thus far, that language, of course, really matters. I think that there's another aspect to the language that we also have to address, which is coded both in the law as well as in legal principles and tests. So quickly, I want to start with a case that arises from 2005. So of course, many in this assembly will know, of course, that we had equal protection guarantees from our earlier constitutions, 56 and 62, but it's only in 1973 that there is a specific bar against discrimination on the grounds of sex alone, as it was at the time, and that this alters in 2010 with the reduction down in verbiage to a bar on discrimination on the grounds of sex. And that opens up certain possibilities, and I want to see progressively through history how it is that we moved from effectively what was, I guess, a formal model of equality, where all individuals must be treated alike and enjoy equal protection of the law, to a forbidden characteristic model whereby discrimination on particular grounds, those which are morally arbitrary and encoded within the sex alone guarantee, have been barred. So I'm going to just start with a case from 2005, which is the Shireen Munir case against Pakistan International Airlines. And the facts of the case there were that there were differential retirement ages between female stewardesses and male pursers. So PIA, the employer, asserted that this was a reasonable classification that did not offend against equal protection and non-discrimination guarantee. And so the test for a reasonable classification is that there has to be an intelligible differential plus a legitimate governmental purpose, right? And that is the threshold that needs to be satisfied. But of course, the justices in that case looked at the fact that, in fact, across two so-called designations, which was between stewardesses and pursers, they were both within the broader category of people who were employed as cabin crew, and that there was only a real difference which was predicated on sex, that otherwise there were no difference in terms of the occupations or the jobs that they were performing, and given this, that this differential treatment was found to be discrimination purely based on sex. Now there's just a kind of mental exercise here that I think it's worthwhile doing, or a set of questions which it's worthwhile to ponder, that given that situation in 2005, had there not been a comparator group which was so easily dissolved in the face of scrutiny in terms of the actual nature of work, would the finding be the same, right? And I'm asking the question here because I want to sort of return to the question whether or not there is space within our jurisprudence or within our legal reasoning for a more nuanced evaluation employing principles of, let's say, disparate impact or indirect discrimination that we can both borrow from and evolve, borrow from different jurisdictions and evolve in light of our particular circumstances. And to buttress that, I'd like to say that a finding of indirect discrimination could theoretically be possible even under a regime that employs the word sex alone, but that it's obviously also bolstered when you have the opening to an even broader kind of designation, which brings in other possibilities or other gender characteristics alongside biological sex alone, or even supplants biological sex.
So ma'am, 5 minutes are over. So can you conclude?
Am I really?
Yeah, kindly conclude. Yeah,
okay.
Please. Yeah.
That was very quick. Okay, so the other question that I want to ask vis-a-vis this case, is this a case that stands for the principle that sex itself cannot be an intelligible differential for the purposes of establishing a reasonable classification in any instance? So I leave you with those two questions, and what I want to say about them is that actually we have a jurisprudence that has evolved over the last nearly 2 decades since the time of that case, which upholds both of those things. So the reason for looking for indirect discrimination is that we arrive more closely at principles of substantive justice and not simply formal justice. And so in that case, what we would be looking at is that are women facing certain detriments which are disguised under neutral criteria in the domain, again right now I'm speaking of employment law, or I would have been in a more elaborate discussion, but that obviously has repercussions or can be a consideration across all sorts of domains. Now, I think what I wanted to say more broadly is that we have seen that vis-a-vis age qualifications being, allowances being made for differential age qualifications between men and women on account of child rearing, on account of, in certain instances, that women who get divorced have to enter the workplace at a later age, things of that sort. Also, actually, there's a very important decision by Justice Aisha Malik, which actually holds that women's, employment opportunities cannot be limited on account of kind of what are paternalistic views about their safety. Other additional considerations include maternity and the like. So I think, but yes, I'll stop there. I can hear you. So
thank you very much, ma'am, because we have really short of time. I am grateful for joining here, although you are busy in your convocation at NUMS. Thank you very much, and we must have learned something out of your interaction with us. Thank you.
Thank you.
So now I invite our last panelist, Honorable Ms. Justice Saman Rafat Imtiaz. Ma'am, I have a question, and you already know that time is running short for us. So, Mike, Mike. Okay.
Is this on? Yeah, can you hear me? I realize I'm the one who's keeping everyone away from lunch, so I'll be very, very quick with what I had to say. My co-panelists have already addressed the issue of the importance of language. I will be concentrating by giving examples of judgments which use good language as well as bad language from the perspective of gender inclusivity. But before I come to the judgments, I would like to refer to a statute, because that kind of has a good ending. We're all familiar with the Civil Procedure Code. Order 5 of the Civil Procedure Code deals with the process of service. And Rule 15 of it allows service to be made upon a defendant through a family member. Interestingly enough, the words that are used in Rule 15 as it exists today, it only allows for service to be received by an adult male member of the defendant's family. So I've highlighted this in a few of my orders, and I'm very happy to share with you that the Rule Committee of the Islamabad High Court took note of it, and they've already proposed an appropriate change in this regard. They've removed the word male from it. The groundwork has been done, and I believe it's going to be put up before the full court very soon. So at least to the extent of Islamabad Capital Territory, the process of service will be far easier. So then coming to judgments, there are a few judgments which I've actually come across myself. They ended up before me. And I'm sure this is a phrase that you all are familiar with, especially the judges, disobedient wife. So that was something that I found very troublesome right from the beginning. Family law is not something that I had practiced much as a lawyer, but as a judge, I deal with family cases all the time. And this is a phrase that was used by, or that is used by lawyers in their arguments, in their pleadings. You may even come across it in judgments. And I thought I would write a judgment about it when I got the chance. But fortunately, the Islamabad High Court has already delivered a judgment on this point, saying that although D.F. Mullah does talk about disobedience on the part of the wife as a grounds for withdrawal of maintenance by the husband, there is no such thing in our statute. And D.F. Mullah, although it is a reliable reference, because it's a good, but at the end of the day, it's only a commentary. It cannot be relied upon as an authoritative source of law. And to that extent, the MFLO is the statute, the governing statute, which provides the wife the the right to claim maintenance if she has been denied by her husband. And there is no defense in that law for the husband to deprive her of that on the ground or pretext of disobedience. So that is something that I think we as judges need to be very mindful of, not to use it, because it's not coming from the law, and it is basically just reinforcing this stereotype that we have in our society, that men are the providers and women are dependents, and therefore it suggests an imbalanced relationship between the husband and wife, where one is superior and the other one is inferior. I could talk a little bit more about it, but I'll move on to the next example very quickly. This was a family case that ended up before me, and it was very interesting because it was about custody and maintenance of 3 children, 2 of whom had already come of age while the proceedings were going on. And the eldest was a son, and the second child was a daughter. So it was very interesting because unfortunately the family had a lot of issues. It was a very toxic relationship between all the members of the family. What I found interesting was that the family court, while discussing the son's behavior towards his father, they kind of spent about like 1 line saying that he was disobedient and that's not very good, but now he's an adult, so nothing much can be done about it. But when it came to the daughter, who was also above the age of 18, the family court went at great lengths to emphasize her disobedience. And more importantly, the reason why the family court considered her disobedient was very interesting, that they use the word marriageable age. The judgment uses the word marriageable age and says that although she is of marriageable age, she is not getting married, and instead she is actually living abroad all on her own and pursuing an education against the wishes of her father. So if we had more time, I could have, I would have liked to unpack this more, because there's so much that's wrong with this 1 line. But I will leave it up to you. I think we can all see what is wrong with it. First of all, marriageable age. There's no such thing. Of course, there is a minimum age that has been prescribed in the law, but that goes for men and women equally. I believe there might be a difference in age depending on which province you're in, but there is no law that says that if you reach a certain age you must get married. And also to pass a moral judgment that she is not getting married despite her father wanting her to, this is very problematic, because and it's actually not just problematic, it's against the law, because marriage is essentially a civil contract and you can't compel or force someone to enter into a contract. What it's doing is it's just sort of reinforcing the stereotype that we have in our society, unfortunately, that women have a shelf life, and so they must get married by a certain age, otherwise the only utility they have will be lost. And this just reminds me of another thing, which is a slight digression, but despite the bell, I'm going to continue. That about 10 years ago, the Council of Islamic Ideology passed a resolution saying that women can become judges at the age of 40. Reason being that by that age they are neither marriageable nor attractive. I wish I was making this up. You can Google it. It's part of our history now that there was a resolution that was passed to that effect. Again, lots more can be said about that, but moving on very quickly, there was another judgment that we might have all come across because it went viral, at least the beginning portion of it. It was a judgment passed in an appeal arising from a consumer court case, where the judge actually compared a vehicle, a car, to a girlfriend. So I don't know how many of you have seen it, but again, rushing through it. Now, before I end, because I think it is important to end on a good note, there are two examples that I'd like to quote, and in the interest of time, I do have citations. I'll skip over it. If anyone is interested, they can come to me and ask for it. One Supreme Court judgment that has finally said what needed to be said, that the term honor killing is a misnomer. It should not be used at all because there is no honor in killing. And by using that term with killing, again, you are subconsciously implying that the victim somehow deserved it or had done something immoral, and to restore that honor or morality, the killing happened. So the Supreme Court has set that right. And then there's another judgment in which the Supreme Court has actually given examples of the phrases that need to be avoided. For example, habituated to sex, woman of easy virtue, woman of loose moral character, non-virgin. These are all terms which need to be avoided. And I think a good rule of thumb that I try to follow as well is that when you're writing a judgment, just be mindful, have that clarity of thought that what you're saying is within the four corners of the law, or is it something which is based on your personal opinion. And your personal opinion obviously has no place in your judgments, because we are all products of social conditioning, myself included. Whatever our views are, beliefs, ideas, thoughts, feelings and emotions, they are based on the environment that we have grown up in, the family that we have grown up in, the education we've got and what have you. That can be subjective. So to all the judges out there, including myself, one has to remember, it's easy to falter, that try not to bring in your personal opinions and try to stay within the four corners of the law.
Well, thank you very much. So I thank you all, my panelists here. You can have your seats now.
Thank you.
And thank you for listening patiently. And I am also saying sorry to my management that they are pressing me. The time is going over. I don't know. So okay. Now what? For lunch? Okay. So now it's the lunch time. And what is the What is the time to come back? Kindly make it clear.
जी थैंक यू सो मच. हम बहुत लेट हो गए आज के सेशन के लिए और वी आर सॉरी. हमने 2 बजे का टाइम दिया हुआ चीफ जस्टिस साहब को और इसके लिए भी माजरत कि आपको जल्दी जल्दी कुछ खाना पड़ेगा और 2 बजे हम रिज्यूम कर देंगे. स्टेज विल बी ऑन, CJP विल बी हेयर, अदर गेस्ट फ्रॉम UN Women एंड यूरोपियन यूनियन विल बी हेयर, एम्बेसडर विल बी हेयर. तो मेरी रिक्वेस्ट है कि आप 2 बजे सारे वापस आ जाएं. थैंक यू सो मच. I seek permission of the Honorable Chair to start this formal ceremony. May I have your permission, sir? I seek permission of the Chair to start the formal ceremony. May I have your permission, sir? Thank you, sir. Honorable Chief Guest, Chief Justice Qazi Faiz Isa, Chief Justice of Pakistan, Mrs. Sarina Isa, Honorable Judges from Supreme Court and High Courts of the region, Excellencies from UN Women, and Ambassador, EU Ambassador, esteemed judges from the District Judiciary of Pakistan, delegates and participants, Assalamu alaikum. Good afternoon. To start this session, I would like to invite Dr. Rina Koenka, who has served as EU Ambassador in South Africa and was the Chief Foreign Policy Advisor to the President of the European Council, Donald Tusk. She led the Central Asia Division and Human Rights portfolio at the European External Action Service. Dr. Koenka was Estonia's ambassador to Germany and later Undersecretary for EU Affairs. Please welcome Dr. Rina Koenka with a round of applause. Please come to the stage.
Thank you very much. Assalamu alaikum and good afternoon. Honorable Chief Justice of Pakistan, Justice Isa, Madam Isa, Honorable Justice Shah, Honorable Judges of the Supreme Court of Pakistan, Judges of the High Court, representatives of the Federal Judicial Academy, dear delegates, dear participants who came all the way to Islamabad to talk about this important topic, dear UN partners. It's my great pleasure and my great honor to address this distinguished gathering. This symposium represents a giant leap in highlighting the importance of inclusive justice in South Asia, and we proudly associate ourselves with this event. Indeed, the European Union firmly believes that access to justice is only fulfilled if it's guaranteed for all, in particular those who are at risk and those who are the most vulnerable. It's a priority, oh that's better, that's much better. It's a priority for the EU's Action Plan on Gender Equality and Women's Empowerment, something that we fondly refer to as the GAP, in external action from 2021 to 27, and it's globally a target under that same program. This legal access to justice is a key priority, and gender is a key priority in EU interventions globally and all over South Asia in order to increase women's access to justice and to foster a responsive justice system which advances women's equal rights, opportunity, and participation. Let me give you an example of how we do that here in Pakistan. Besides raising the issue politically and in our sectoral dialogues, we provide concrete support under the Deliver Justice program, which is co-implemented by UN partners, UN Women, UNDP, and UNODC. And today's conference is a part of that project. The project, which fits the progressive vision of the Chief Justice, supports the government and the judiciary at federal and provincial levels to improve policy frameworks and to build the capacity of all actors in the criminal justice system. A strong focus of this program is on promoting the effective representation of women and improving capacity within the criminal justice system to promote and safeguard the rights of women and girls. This includes, for instance, raising awareness and providing free legal aid for women litigants on the demand side, and on the supply side, it also provides for training of women staff and upgrading infrastructures that benefit women in the justice and law enforcement sectors. So while we are here gathered to support inclusive justice, I note with concern that the latest Global Gender Gap Index is not looking so great for Pakistan. It sees Pakistan sliding down from 142 in the index down to 145 out of 146 countries. This data should prompt questions for all of us about our concerted efforts for gender mainstreaming in all spheres of life, including when it comes to the judiciary and law enforcement. Women's representations in these sectors remains alarmingly low. This presents challenges for providing inclusive justice. It's encouraging to witness a growing number of women asserting their presence in the legal fraternity, or should I say the legal sorority, in the judiciary and law enforcement agencies. And with the support of this project and the vision of relevant authorities, we note, for instance, that police recruitment drives have contributed to the increase of the number of women police officers in the merged districts of Pakistan by 123%. That's an amazing number, but I have to say that the bar was low. In 2022, there were 22 female officers, and in 2023, that rose to 49. So more needs to be done, and at the same time, we need more male champions for inclusivity, he for she, as we know. Gender equality and inclusion are best achieved when embedded in all activities and all sectors. While the EU is about to launch a new project on women leadership in the democratic process in Pakistan, our delegation also managed to ensure that 100% of our new EU-funded actions across all areas of our programming cycle are gender sensitive. What that means is that women's and girls' needs, their preferences, their constraints have been taken into consideration when programs are designed from the get-go and when they're implemented. And this goes, as I said, across all priority areas that we work on here in Pakistan. Turning back to the symposium at hand, I congratulate UN Women for completing, with EU support, a landmark study on the role of the judiciary in expanding women's rights. This study documents how Pakistan's apex judiciary has demonstrated a high degree of sensitivity to women's rights and, against all odds, sought to uphold international human rights standards, rights and principles, while adjudicating cases related to heinous crimes against women. The study references important judgments, including by the Chief Justice of Pakistan, who reminds us that, and I quote, "Denying females their inheritance undermines their economic independence, prevents a rise in their standard of living, and concentrates wealth in male descendants," unquote. These reminders should now translate into concrete actions. I thank all of you who have traveled here from far away, from different provinces in Pakistan, and certainly different South Asian countries as well. We have a very strong contingent from South Asia outside of Pakistan here. Great to see that. I wish you substantive talks. I know you have had them for a couple of days now. And I understand a lot of good ideas have come out of these discussions up to now on how to improve inclusive justice, not only in Pakistan, but across South Asian judiciaries. Thank you very much.
Thank you, Dr. Reema Goenka. Mrs. Sharmila Rasool is the country representative for UN Women Pakistan. She is the country representative and is an attorney at law of Supreme Court of Sri Lanka. Ms. Rasool has held numerous leadership positions in Pakistan, Sri Lanka, Laos, Bangladesh, and UN. Her extensive experience includes working on rule of law, justice, and human rights programs, demonstrating a strong commitment to gender equality, women empowerment, and human rights. We welcome Ms. Sharmila Rasool to the stage.
Thank you, Shazia. His Lordship, the Chief Justice of Pakistan, Qazi Faiz Isa, Madam Isa, Dr. Reena Kionka, the Ambassador for EU in Pakistan, Sir Mohammad Yahya, our Resident Coordinator for the UN in Pakistan, the Pune Judge of Supreme Court, His Lordship Justice Mansoor Ali Shah, justices, judges from Pakistan, and visiting delegations from Nepal, Thailand, Maldives, Philippines, legal fraternity, staff members of the UN, and my own team, UN Women. Assalamu alaikum, and a very good afternoon. I am very, very pleased to be here on my own behalf and on behalf of my agency, UN Women in Pakistan. I've been given a very difficult topic to talk about. Ignore the challenges, carve out opportunities so that our future is better. And this was given to me by the DG of the Federal Judicial Academy, Mr. Hayat Ali Shah and Mr. Fakhr Zaman, to really put me in trouble. But I'm going to try and do my best to sort of use this opportunity to reflect on what I heard in these 2 days, where legal minds from Pakistan and from the subcontinent came together to debate on what is inclusive justice and what's the way forward for us. What I'm hearing in all the sessions, and I must tell you, these sessions were of immense value. They were very interesting dialogues, some debates that brought out certain concepts very clearly. What I'm hearing about inclusivity of justice in the rest of the last 2 days is that justice cannot thrive without inclusivity. Justice, by its very nature, needs inclusivity. So I'm sure that most of you agree that's a concrete conclusion that we have come by the time that we are closing this session. Globally speaking, not just for Pakistan, we all know, if we put our hands on our hearts, that justice is a distant concept for us. It's going far and far away from us. This is especially for people who are left behind. Under the SDG agenda, we say we do not want to leave anyone behind, but we are not exactly doing that. We are leaving behind the women, we are leaving behind the minorities, we are leaving behind the poor people, people who are living in poverty. For them, justice is an unknown concept. This gap not just takes away the sanctity of justice, which is a very pure concept. It takes away from them the opportunities. It creates barriers for them and hurdles for progress. But today, I promise you, I'm not going to bore you with the challenges because my topic is to look at the opportunities. So we are not lamenting about the gaps and the challenges for once. We are going to be inspired with the opportunities that we have ahead of us. So for a moment, I invite all of you to go to a global platform and imagine if we were to rewrite this narrative, how will our future look like? A future that is befitting for our generation to hand down to the next generation, our children, our grandchildren, and the generations to come. Imagine how it would look like if we were to rewrite the narrative. I'm sure if you close your eyes, everybody's going to in one voice say, justice should not be a privilege. It should be a birthright. A birthright, ladies and gentlemen. By birth, you are entitled to justice. That's the narrative we should rewrite, not just for Pakistan, but for the globe. Imagine, thank you. Imagine how it will look like if we apply that concept here, locally. It will not just be a smart thing for Pakistan to do, to invest on inclusive justice. It is a strategic thing to do. It should be a strategic investment for the future of Pakistan, because it will not only benefit the legal fraternity and the legal system, it will accrue benefits beyond the legal system. It will bring benefits in terms of your economy, in terms of social stability, in terms of your political fabric, because you, through an inclusive justice system, will hold duty bearers accountable towards the claim holders. So, what are the opportunities that we have? I would start not far away from this room. I would start from this room. This very symposium, this very space now, this very moment that we are all living in is an opportunity, because we have come together. The ones that are advocating for justice, we are all here. So we are like-minded. This symposium could not have happened if not for the openness of His Lordship, the Chief Justice of Pakistan. If not for his willingness to engage with the UN. Now, the development sector would know that it is not a common occurrence where the apex judiciary is engaging openly in other parts of the world. So I would say the first opportunity we have is the leadership of the apex judiciary in Pakistan to engage and be open, invite opinions, not just from the legal luminaries in this country, but legal luminaries from the other parts of the world. So that's our first opportunity that we need to grab. And His Lordship has started telecasting, televising important cases, and that, I would say, is a first step of really bringing the transparency, showing the world, showing Pakistanis, this is what justice is all about, which is a cornerstone. Transparency, I'm sure I don't have to preach to the lawyers who are in the room, is a cornerstone of bringing inclusive justice firmly forward to Pakistan. The second opportunity is linked to the first opportunity. This is the digital revolution. We are now undergoing a digital revolution. The generative AI is upon us. It is influencing a lot of opinions because people are constantly referring to the generative AI to write content for them. So the generative AI, which is gender bias, starts writing things that are gender biased. So it's affecting us without us knowing. But if used wisely, the digital revolution could be a double win for us, because it will bridge the gap, the gender-digital divide, if we use wisely, and it can also be used as a positive tool to dispense justice from a courthouse to any place where there are geographical barriers where people cannot come. It is already happening to an extent, but something that we should build on. The digital revolution, ladies and gentlemen, should not be another human revolution that leaves women behind. The agricultural revolution, the industrial revolution left women behind. We cannot let this revolution, while we are all here, responsible human beings, to leave behind women again. So, it is an opportunity, but if used wisely and appropriately. What's the third opportunity? The third opportunity is the urgency and the drive that the apex judiciary has shown to bring inclusive justice, make inclusive justice a reality. And now I'm going to borrow our puisne judge's words. Justice Mansoor Ali Shah, yesterday in the morning, spoke at length about this issue. I wish it was televised in the country so that everyone, every mother, father, girl, boy, man, woman could have listened to what he said. He said, where are the women? Where are they? And then he said, Pakistan is now trapped in the 17% lull or a stagnation. Now the 17% is not a commission he's talking about. That's the gender parity, average gender parity within the justice sector. So it captures the lawyers, the senior judges in the tax courts, the district judges, and the Attorney General's department. I hope I covered your plea. So that's the drive that we need. And we encourage, Your Lordship, the drive that you have shown and the urgency you are also showing. That's our third opportunity. Just to elaborate on the third opportunity a little bit, I will borrow the words from our federal ombudsperson who is not here now. She said, enough is enough. Let's not try to change the women anymore. Women, you need to fight for your rights. Women, please capacity build yourself. You need leadership skills. You are not fit for purpose. Time to stop doing that, and time to change the environment so that it's conducive for women. Then I borrow Justice Aisha's words from Maldives. She prefers to be called as Shujun. She said, it's not about the what, it's about the how, and holding ourselves accountable. How do we walk our talk? So that's our third opportunity, the drive, and how do we sustain that drive through those wise words that were uttered in this forum. The fourth opportunity, and then I'll be gone. The fourth opportunity is, I'd say, the biggest that Pakistan at the moment has. It's the intergenerational change that Pakistan is now undergoing. There are young people in this country, 64% of them are young. But do we really understand what they're saying? Do we understand their language, and do they understand our language? I think we need to build this bridge this communication gap. And what best way to bridge a communication gap, the next generation leaders, by talking to them of the just societies that we dream for them. How do we make it so inclusive that their concerns, aspirations are addressed in this journey of making the judiciary more inclusive? And to this end, I must mention our generous donor, EU, which has made all this possible, is really helping us to bring these young voices by increasing gender parity within the justice system, not just within the judiciary, but within the police, within the Attorney General's department, within the prosecution. So my humble thanks to the ambassador and Sebastian, who's here from the EU, has been an immense support to us. Last but not least, the opportunity, the last opportunity, is we ourselves. You as an individual, you as a professional, you as a legal luminary, you as a human being, we are responsible. This is not something one sector, the judiciary or the police or the bureaucracy, can do alone. It requires collective effort and consistent effort. Every time we as individuals talk about or challenge discrimination, each time we amplify the voices that are unheard, the voices that are muted, each time we identify an unmet need of the people, and here in this case, especially the women, we are one step closer to inclusive justice. With those words, I really thank Shazia for giving me and being patient, not ringing the buzzer on me. Thank you so much, and it's been a great pleasure to meet all of you. Let's continue our good work. Thank you. Assalamu alaikum.
Thank you, Ms. Rasool. Mr. Muhammad Yahya, the United Nations Resident Coordinator and Humanitarian Coordinator in Pakistan since January 2024, has over 20 years of experience in development and peace building. He also coordinated the Africa Regional Program for UNDP and supported post-conflict recovery in Afghanistan and Liberia. Please welcome Mr. Muhammad Yahya to the stage.
Thank you. Assalamu alaikum. I'm happy to be here. Chief Justice of Pakistan, the justices were all here, the EU ambassador, distinguished guests, UN colleagues, thank you for having me. In the future, I should make sure I look at the agenda not to speak after the UN women rep, but I'm delighted to be here today. I would like to begin by congratulating the Federal Judicial Academy, the EU and UN Women for this organizing this successful symposium on inclusive justice. I also want to appreciate the Supreme Court of Pakistan for its patronage for rule of law programming here in Pakistan. Justice, as we know, is a cornerstone of any society that aspires to build dignity, rights, and aspiration for its people. In Pakistan, the quest for justice is not merely a legal mandate, but a moral imperative that resonates across every segment of society. The United Nations remains steadfast in its commitment in supporting Pakistan in this noble pursuit. Over years, Pakistan has made a significant strides through establishing a more just and equitable society, reforms in the judicial system, advancement in human rights, and efforts to ensure gender equality are commendable. The dedication of various stakeholders, including government bodies, civil society organizations, and international community has been instrumental. However, as we celebrate these milestones, we must also acknowledge that gaps and challenges remain. Our journey towards a just society is ongoing and requires a continuous and concerted effort to address system-wide challenges. Our Secretary General called gender equality the unfinished human rights struggle of this century. He emphasized on the need for a legal system that eliminates discriminatory laws and practices that hinder women's rights. To accelerate towards an inclusive justice system here in Pakistan, we at the UN have identified 5 key areas of priority. One is access to justice for all, ensuring justice is accessible to everyone, regardless of their socioeconomic status, gender, ethnicity, religion. Second, gender justice, addressing barriers for women and girls in the face of accessing justice. Issues around gender-based violence, ensuring equal representation, and empowering women through education and economic opportunities. Third, gender inclusivity in the judicial system, and I think it was just mentioned, the challenges that still we have to overcome. Fourth, child rights and protection, strengthening efforts to protect children from exploitation, abuse, and neglect. And finally, reformative justice, shift the criminal justice to focus on rehabilitation, reintegration, to reduce tendency and build a compassionate society. United Nations is committed in supporting Pakistan in these critical areas. Our collaborative efforts span across various dimensions. For example, we have this ongoing initiative, joint initiative between UNDP, UNODC, and the UN Women around collaborating with the justice sector around institutional building. In closing, I urge each of us to take insights and resolutions from this symposium. I think many of you have been to many symposiums, and I was speaking to the representative of UN Women today. The biggest challenge with symposiums is the follow-up, the implementation, specifically on this issue. How do we move from here to strategies and, more importantly, to implementation? The journey towards justice is not a responsibility of a single entity. It's a collective endeavor that demands our united effort. Together, we can make a leap towards a more just and equitable Pakistan. Shukriya, Pakistan Zindabad.
Thank you, Mr. Muhammad Yahya. Justice Qazi Faiz Isa is a distinguished jurist and currently serves as the Honorable Chief Justice of Supreme Court of Pakistan. Known for his unwavering commitment to justice, human rights, and judicial independence, Justice Issa has played a pivotal role in shaping Pakistan's legal landscape. His judgments reflect a deep understanding of the constitutional law and a strong advocacy for the rule of law. While protecting the rights of women, Justice Issa believed that economic deprivation of women prevents their full participation in all spheres of life. It was held by Justice Issa in a judgment titled Ghulam Qasim versus Razia Begum. Then again it was held by Justice Qazi Faiz Issa. A woman is entitled to her property and it cannot be disposed of without her consent. That was held in Fawad Ishaq versus Mehreen. Naseem Ullah versus Nahid Begum is another landmark judgment on the rights of wife. Today, we are honored to have Chief Justice Qazi Faiz Issa to deliver a distinguished address where he will share his insights. Please welcome with a round of applause and with a standing ovation to Chief Justice Qazi Faiz Issa.
Thank you very much for those words. I am deeply humbled and not deserving of them at all. I would like to acknowledge and welcome Dr. Reena Kionka of the EU, Ms. Sharmila Rasool, Mr. Mohammad Yahya of our session, the other distinguished foreign delegates, my distinguished colleagues and distinguished participants. Assalamu alaikum. Simple greeting applies to everyone. Peace be upon you. It's gender neutral. It incorporates singular and plural. There are many other things which we tend to forget from our own historical tradition. For instance, you will note that Sharmila Rasool uses the word Ms. This is not a Western invention. This is predates, it's ours. In Pakistan and many other areas, we call a lady, whether it is a child, widow, or a married woman, single woman, musammat, short MST, sometimes you write in judgments. So there are a lot of positives which we forget about our own tradition and culture. I'll just begin with the positives of that there are in the Constitution of the Islamic Republic of Pakistan, and I quote from the Constitution, and it says, "Steps shall be taken to ensure full participation of women in all spheres of national life." So this is part of a Constitution, and legislation is subordinate to the Constitution and must conform with the Constitution, cannot conflict with it. There is another fundamental right which can be categorized as affirmative action. That's in Article 25, which says that making any special provision for protection of women. So you can introduce special laws for women's specific, and there are such laws. For instance, in jobs, in government jobs or public sector jobs, you can fix a certain percentage that for women. The same applies in admission to universities, and we have such laws as well. Actually, the men of Pakistan are now complaining that because the women come on the merit seat and they also come on the reserve seats, and invariably they're doing better than the men in educational institutions. It doesn't mean that they cannot come on the merit seats, but there's also a percentage reserved for them, for women, specifically for them. There's also an interesting concept which does not exist in many countries of the world, and that is reserved seats in the National Assembly for women. These are not, it does not mean that only women can come on these seats. Women can be elected on the general seats in the National Assembly. So that is gender neutral. You can be man or woman to contest that election. But then you have certain reserved seats, which is an indirect form of elections through proportional representation. And in the National Assembly, there are 60 such seats, which constitutes about 18%. And the same is reflected. Pakistan is a federation comprising of provinces, and the same is reflected in the 4 provinces. The reserve seat percentage is roughly 22% of the total seats. There are other specific provisions in the constitutions regarding inclusivity and protection, and I quote again from the Constitution: the state shall protect the marriage, the family, the mother and the child. This is a constitutional provision. Another one is a fundamental right, is free and compulsory education to all children of the age of 5 to 16 years. As you know, one of the attacks is on women receiving education, and this happens in Pakistan as well as across the border, and it is considered as if the women or girls are not supposed to be educated. It's a fundamental right in our constitution. It's a right which the Almighty not only makes us obligatory on Pakistan being an Islamic Republic. I do quote from the Holy Quran that the first word, that the first revelation came in the form of a directive from the up high, and it was Iqra, read. There is no argument here, it's gender inclusive. It applies to everybody. So there is a great tradition of knowledge. I mean, without that is the very first, I mean, it could have been a number of other directives coming from up high, but the word that was chosen by the Almighty, we believe that the words in the Holy Quran are the words of the Almighty, was to read. And it goes on, the same revelation goes on about the kalam, the pen, teaching, so it's all interconnected. That's the first revelation. Having said that, we have, sadly, when we look across the Muslim world, we have forgotten all of our collective history, a religion without which, without the role of women, there would be no religion. The Prophet Muhammad, peace and blessings be upon him, the first revelation that he received, he literally ran to his wife, and she was so scared and terrified, and she comforted him. We as Muslims, it's a pillar of our faith to do Hajj once in a lifetime, if you can financially afford it. It was the running of a mother, and every Muslim has to emulate that example of running in the footsteps of the mother, the Sa'i at Makkah, where we literally run in the footsteps of Bibi Hajira, peace be upon her, and her son, Prophet Ismail, peace be upon him. So these are traditions which we have forgotten. Maryam is the most revered of women, named more so than in the Bible. Chapter of the Quran is named after her. And many of the laws in Pakistan connect religion with the laws in Pakistan. For instance, there is, in the Pakistan Penal Code, these are the offences that are that various offences are compiled together in the Pakistan Penal Code, and all offences, chapter 16, which is against the body, which includes murder, section 338F specifically states that where the language is not clear, you will be guided by the Holy Quran. I said I'll mention the negatives. A negative is what in the West has come to be known as honor killings. Yes, they do take place. Unfortunately, the word honor has been, the word that is used here is ghairat, which has been mistranslated to honor. Actually it comes closer to arrogance. And arrogance is takabbur, and takabbur is a sin in Islam. Hell, and I quote from the Holy Quran, hell is the abode of the arrogant. This is chapter 16, verse 29, and again on chapter 39, verse 72. So there is this great tradition. We can easily learn from this tradition, and all the more so when it advances inclusivity, when it advances justice for all. There is, for instance, honor killing cases we come across, but there's another concept of a law which does not exist in any I have to be careful with language nowadays, with Western countries, for want of a better phrase, let's put it this way. If you accuse, impute the character of a woman, insinuate something immoral about her, in Islam it is a criminal offense. It's called qazf, and it has also been incorporated into the law of Pakistan, a law sadly which is rarely, if ever, applied, and it's in two laws actually. It's the qazf specific law which mandate a punishment, which is the punishment in the Holy Quran of 80 lashes, and also in section 496 of the Pakistan Penal Code prescribing a punishment of 5 years. Sadly, this is, if I've never come across it being really implemented. So, but we have the opposite thing of adultery, for which that is a completely, it is not only morally wrong, legally wrong, it is also purely, from a purely theological Islamic point of view, it is prohibited, because a punishment for that has been prescribed in the Holy Quran, and you cannot exceed a punishment that has been prescribed, and which is not the punishment of death, which honor killings, which they falsely call or honor killings, attract here. The other aspect here is that for the punishment of adultery, the test is so severe, it is almost impossible. Whether loose charge is made against a woman and she's done to death, but if you actually apply the law, which is getting 4 adult witnesses to have seen the act, and if you fail, you get punished for qazf. So irrespective, so it's almost an impossible test to meet, but sadly honor killings do take place. How do the courts come in? How can they nudge things one way or the other? There is a provision in the Constitution, not in the Constitution, in our law of evidence, Article 122. And the article, if I will, you'll understand what I mean after I've read it. Usually the burden of proof in every criminal trial is upon the prosecution, that's a given. And it has to be proven beyond reasonable doubt. What happens here, it's also connected with honor killings, or killings in the house. I don't know how she died. She is got a bullet wound in her thing, and who are the witnesses? There are no witnesses. All the witnesses are complicit. So the Article 122, when any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. So in a way, the burden of proof shifts. This has been interpreted by the Supreme Court. I cited other precedents also, but the point was clearly made. And I just read a bit from that judgment, that with, quote, that with regard to vulnerable members of society, such as children, women, and the infirm, who are living with the accused or were last in his company, the accused ought to offer some explanation of what happened to them. If instead he remains silent or offers a false explanation, he casts a shadow upon himself. So this helps in bringing the perpetrators of these kind of crimes against women to be made accountable. So this is how criminal law judges can interpret existing legislation to fulfill not only the laws of Pakistan, but the laws of the Almighty. let me clear up a few misgivings also. Generally, and most Muslims are guilty of the same misunderstanding, is the evidence of a woman is half that of a man. Nothing could be further from the truth. The Quranic verse is there to protect the interest of women. So you enter into agreement with a lady and she doesn't quite understand what she's giving away with future financial transaction, and she gets stuck. The other verse, which nobody really refers to, it again connects with an allegation of adultery by a husband or a wife, by a husband against the wife, and there are no witnesses. So here the testimony of the wife has precedence over that of the husband, and this is Lian, and it is the chapter of the light, Surah An-Nur, 24th chapter of the Quran, verses 4 to 10. It is literally, he accuses her and he swears, and the wrath of the Almighty will be upon him if he lies. She swears and she does the same thing and he does the same thing, and the final one is the woman's say. So it's testimony, precedence is taken here of the testimony of women. The other aspect is, another negative in our society is the law of inheritance, which is very clear cut. It's specified, shares are specified. You don't have to really think. These cases should take literally 5 minutes to decide and dispose of. Should never see the Supreme Court, let alone even the High Court. But the male members of society deprive ladies of their Quranic shares, which in addition to breaking the laws of Pakistan is a sin. And the matter takes forever to come to the Supreme Court, and because there's no downside, you keep the lady involved in litigation, and even if she ultimately wins, you will have had the benefit of the property for a considerable period of time. So what the judges can do, impose very heavy costs in this kind of frivolous litigation, or just before death of a father or a mother from whom one inherits comes this false gift that actually just before his death the son comes forward and says the property was gifted to me. Another device used to deprive women, and endless court hours are spent on this, and if the courts were very severe on not only costs but on the applying the standard of proof, matters would get resolved very quickly. So matters, there are many such cases, and I can go on. There are positives, but there are also negatives. So these are the devices that one come and use, because the Constitution, I don't think there is any fault in the Constitution. The laws are also pretty all right. It is the application of the laws, and here the courts come in and all of us come in, and how you apply the laws and how do they get a particular result. Another aspect is societal, which judges can't change, society changes. The founder of the nation, Muhammad Ali Jinnah, who we lovingly refer to as Qaid-e-Azam, the great leader, always because his marriage didn't last, his sister went with him everywhere. He ensured that in the highest body of the All India Muslim League, there was a lady, you've seen in the photographs, and that tradition, unfortunately, is waning, and we don't see men who are in office accompanied by wives. This also has a very positive effect, in my opinion. So if we project, that is something which we can easily redress and resolve, all of us. And so I will just conclude by clarifying that I was given a lot of thanks, but the actual person who deserves the thanks is Justice Mansoor Ali Shah, who has not only made this possible, who has also not made this possible, but is in charge of the Federal Judicial Academy, and from a more or less dormant organization has brought it to life. Thank you very much.
Thank you so much, Honorable Chief Justice of Pakistan. Now I request Honorable Director General, Federal Judicial Academy for a vote of thanks to the participant of this symposium. A big clap for our DG because he has been a driving force behind all this. Thank you.
Bismillahirrahmanirrahim. Honorable Chief Justice of Pakistan, Qazi Faiz Isa, Honorable Sayyid Mansoor Ali Shah, Senior Penal Judge and Advisor to the Board of Governors, Federal Judicial Academy, Excellency Ambassador EU, Excellency Resident Coordinator UN, Sharmila Rasool, Lansana, Honorable Judges of the Supreme Court, Honorable Judges of the High Courts, delegates from South Asia and East Asia, and dear and more dear district judges of the district judiciary. You always need words to say thanks, and today I don't have the words to say thanks, because the kindness which Honorable the Chief Justice has shown to the Academy and to this conference, I don't find words for that. I don't find words for Honorable Justice Mansoor Ali Shah, who not only gave us time during the conference, but if I say that this would have been impossible had he not given all his time, and for the last almost 1 month, he has been with us. He has been with us even when he was in America, and daily we used to receive his chats and his directions. So I want that I should thank him through a very big clap. Thank you. I am thankful to Honorable Justice Aisha Malik, who guided us at the time when we needed the guidance. And he gave her full time, and it was really, we felt while interacting with her that women when they are in the leadership, they prove to be, I don't want to use the word more than men, but she proves to be more than men. So a clap for her as well. I must pay special thanks to our Honorable Sarina Isa, the wife of Honorable Chief Justice. She behaved like a mother, and always we saw her and we felt that some mother is with us, she is praying for us, and her hands are at our heads. So clap for her, please. I am thankful to the foreign delegates who gave their time and they shared their experience. Really, we are grateful for them, and I want that we should also give a big clap to them, for them. We are thankful to EU for funding this conference. We are thankful to UN Women, and particularly Lansana and Sharmila. Sharmila, once we worked together in Khyber Pakhtunkhwa, and we declared her a sister of the Khyber Pakhtunkhwa, and today I want we should declare her sister of Pakistan. I am thankful to my team, rather our team of the Federal Judicial Academy. You worked hard, and especially to Fakhr Zaman, our Director of Academics, a big clap for him. Shazia, you did a lot, and a clap for her as well. So, without wasting further time, I am thankful to all of you, and to particularly to the judges of the district judiciary. Thank you all. Thank you very much.
Now it is time for some mementos. So I would request Honorable Director General, Federal Judicial Academy, to be to please be on the stage. And I request Honorable Chief Justice Qazi Faiz Issa, the Chief Justice of Pakistan, to please come on the stage for a souvenir which we want to present. I request Honorable Justice Sayyid Mansoor Ali Shah to accompany Mr. Hayat Ali Shah in presenting the souvenir to Chief Justice of Pakistan. I also request Ms. Sharmila to please come on the stage and be a part of this team, and Muhammad Yahya. Okay. Before the souvenirs, UN team wants to present something to Honorable Chief Justice of Pakistan, Honorable Justice Mansoor Ali Shah. That is some he-she champion ceremony. So Ms. Nabila and her team is also here. ठीक है this
one can have a mic. Can I say that? This is a he for she global UN Women campaign in which we acknowledge the work of men champions for gender equality and women empowerment by giving them the he for she pin. And today on stage you see champions who are working in Pakistan. A big hand, and with this pin, they also commit to do more and inspire you to join them.
The pin is for Honorable Chief Justice Sayyid Mansoor Ali Shah and Mr. Yahya. And our Director General for the Regional Academy, Mr. Hayat Ali Shah.
To our very own resident coordinator. It's my great honor. He's my brother.
So we have 4 he and she champions here. And we really are proud of them. Thank you, UN team. I would request Mrs. Sarina Issa to please join us on the stage for the presentation of this souvenir. नहीं आप देंगे ना दोनों आप और डीजी साहब मैडम को शास्त्र This is for Mrs. Sarina Issa, and we have another souvenir for Honorable Chief Justice of Pakistan.
ये ले लीजिए
जी आप पीछे खड़े And then another souvenir for Honorable Chief Justice. Now I request Honorable Chief Justice of Pakistan to give souvenir to Justice Mansoor Ali Shah. And for Mrs. Mansoor Ali Shah, she was with us for the whole day long yesterday. We are really thankful to her. So please, this is for Honorable Chief Justice, Chief Shah Sahib, Mansoor Ali Shah Sahib. Plate, take your plate.
Why don't you tell them what the motto? उसका भी बताना, वो कहते हैं insignia जो आपने बनाया.
Yes, it includes men and women. All the places belong to women where men are present. So this shows that we are there with you. That's why we have invited all the spouses of the judges. Now I will request Honorable Chief Justice to present the same souvenir to our Director General, Federal Judicial Academy.
ये रखिए
प्लेट कहाँ गई?
जरा जल्दी क्विक करें अब तक.
Now I request Justice Aisha Malik, the Supreme Court of Pakistan, to please come and receive your souvenir and the cultural souvenir as well. थोड़ा सा जल्दी करिए. थोड़ा सा जल्दी से.
This is so
There is another one. That was a shield, just a memory, and this is gift from the UN Women. Now I request Justice Sapna Pradhan Mala, Supreme Court of Nepal, to please. Okay. I will request Honorable Chief Justice to please hold, stay back. आप डीसी साहब को पकड़ाते जाना होगा.
जी श्योर देखिए नूर खुले इश्यूज ना
बेग भी है ना, बेग भी है. जल्दी जी बक्सा
ये फिर कोई ले लिया करे यार.
We have already presented something cultural to the honorable delegates when they visited Federal Judicial Academy. I request Justice Santaria, Appeal Court, Thailand, to please come on the stage and receive your souvenir. साथ ही पकड़ा दो ना, साथ ही पकड़ा दो. Now I request Justice Aisha Shadeen Mohammed, Supreme Court of Maldives, to please come on stage and receive your souvenir.
बस एक ही को रिपीट करते हैं ना, बार-बार क्यों लाते हैं?
हाँ इनको एक ही रिपीट करते रहो, आप पकड़ लें दोनों चीज़ें. अब थोड़ा आगे बढ़ ये मैं उठा देता हूँ. देर हो रही. Now I request Judge Maria Josefina from Trial Court Philippines.
नहीं इनका डब्बा दे इसका. दोनों दे one
This is more better than showing the things.
चलो इधर ही. I just hold it.
Judge Maria Josefina, एक ही चीज पास रख ली और बुरी बार देती जाए. I request Ms. Zarizana Abdulaziz, the gender expert from अभी वाशिंगटन DC से आएंगे। ये पकड़ते जाएं, यही देते जाएंगे। Now I request Dr. Reena Cuenca, Ambassador of European Union, to please come on the stage and receive your souvenir.
Thank you for being with us. Thank you, sir.
We believe in inclusivity, and that our logo also shows. So next is Mr. Lansana Women, country representative of UN Women Pakistan. Pakistan.
Thank you. Please sign me.
So include more men. I request Muhammad Yahya, Mr. Muhammad Yahya, UN resident coordinator in Pakistan, to please come to the stage and receive your souvenir. I'm inviting everybody for the souvenir, so I'm just calling the names now to save the time. I will request Ms. Sharmila Rasool, country representative right now for Pakistan. She is representing Pakistan currently, UN Women.
That's the sister of Pakistan?
The sister of Pakistan, yes. I request Justice Alia Neelam, Judge Lahore High Court. I request Justice Alia Neelam. She has left. So we will be sending her there in Lahore. Yes. She has left perhaps for some emergency. Justice Muhammad Amir Nawaz Rana, Judge Balochistan High Court. I request Justice Saman Rifat Imtiaz from Islamabad High Court. Next, I request Justice Umar Syal from High Court of Sindh. Ms. Fozia Vikar has left perhaps because of some urgency in Lahore. She had a meeting to attend. So now I'm starting with the other panelists. I request Muhammad Amir Munir, faculty member FJA, to please come to the stage and receive your... Sorry. Before Amir Saab, I'm sorry, I just forgot. Justice Dr. Khurshid Iqbal from Peshawar High Court. I'm sorry, sir. It just skipped my mind. Thank you for reminding me. Now, Mr. Amir Munir, faculty member of JA, the panelist, the moderator who moderated the fourth session.
Just this?
Mr. Amir Munir, Judge Amir Munir, I would say. Additional District and Sessions Judge, Hina Muzaffar from Lahore High Court. करीब बैठाया हुआ था. वदिया मुश्ताक मलिक, Additional District and Sessions Judge from Peshawar High Court. Dr. Rahim Awan, DG Ilaja. Dr. Samza Fatma, BZU Multan. Ms. Munazza Hassan, Nisar, Lahore School of Economics. Ms. Nida Usman Chaudhary, a panelist. These are all our panelists in different sessions. Ms. Marwa Khan Chima from LUMS, and Ms. Rida Hussain, FGEH Law Firm.
Who's next? He's done the report.
अच्छा अभी चीफ साहब को वेट करना पड़ रहा था, इससे बेहतर है हम वेट करें. I request Mr. Fakhr Zaman to please receive your hard work souvenir, reward of your hard work. Mr. Fakhr Zaman, the team leader of jail, District and Sessions Judge from Peshawar, but currently he is the Director of Jail.
She's a linguist. Where is the thing?
Then we have Marwa. Okay.
Young Rida, please come.
I request Mr. Yunus Khalid, Team Leader ROL and Governance UN Women, Yunus Khalid. And then Shahzab, Mr. Shahzab from UN Women.
But you did well with the answer. You can't take this. Yeah. Give a regard to your parents.
मैडम पहले हैं, मैडम मरवा, इसके बाद फिर आप ठीक है, आप आगे आ जाइए. सर नहीं, वो आखिरी जगह से एक रह गया. Mr. Fakhr Zaman, please come forward. यहाँ पे आ जाएं आप. Mr. Shahzab, इस तरफ आ जाए. वो उधर से कंफ्यूजन हो रही है ना, वो फिर पता नहीं चल रहा. उधर वाला वो खड़ा ही रहता है बेचारा. And I think for my own hard work, I also have earned a shield. So for me, thank you so much.
Very well done. Thank you. Thank you. Last but not least. Thank you, sir.
Thank you so much, Honorable Chief Justice of Pakistan, Justice Mansoor Ali Shah and DG of jail. You can have your seats, please. And we have a tea, a high tea maybe. You can have your tea. Thank you so much for being with us for 2 days, for listening us patiently, and for enjoying and making our moment a successful event. Thank you so much.